Good afternoon. The Appellate Division, First Department, is now in session. We're going to begin today's session with the calling of the calendar. When you hear your case called, please identify yourself, and then I will confirm with you the amount of time that's been allotted for your oral argument. The first case is People versus Anonymous.
Good afternoon, Your Honor. This is Ria Trivedi from the Law Office of Ron Kuby for Defendant Appellant.
And this is Mary Ann Stracudano for Respondent from the Office of Darcel Clark.
Right. And the appellant is afforded 6 and 2 for rebuttal, and the respondent is afforded 6 minutes for argument. Escobar versus MRS Realty.
Good afternoon, Your Honor. Howard R. Cohen from the Office of William Schweitzer and Associates for the Plaintiff Appellant.
Glenn Kaminska with Omni Demers McManus, counsel for the defendant respondent.
All right, Mr. Cohen, you'll have 5 and 2 for rebuttal. And Mr. Kaminska, you'll have 5 minutes for your argument.
Thank you, Your Honor.
Nanan L. versus Stephen L. Either party here?
Your Honor, it's Renee Cathwala from Oric Harrington Sutcliffe for the respondent in the Nanan move.
Right, is Ms. Advocate online with us?
I'm sorry, Your Honor. I had you on mute. I apologize. Jason Advocate, Advocate LLP for the appellant, Stephen.
Okay. All right. And Mr. Advocate, you are allotted 4 and 1 for rebuttal. Mr. Kathwala, you have 4 minutes.
Thank you.
Jacob versus Iron Horse. I hope I'm pronouncing that correctly. Please state your appearances.
Good afternoon, Your Honor. Otto Chang from Milburn Macris, Plus Status and Sidon for the defendant appellant respondent, 108-110 East 116th Street. Good afternoon, Judge.
Good afternoon.
Good afternoon, Your Honor. Thomas Tordo for defendant appellants respondents Iron Horse and Bush.
Good afternoon, Your Honor. Anthony DiStefano from Morrow Lulling the Party for respondent appellant Ray Steele.
And Judge Brian Isaac for the plaintiff respondent from Pollock, Isaac, and DeSico.
Thank you. Mr. Chang, you have 4 and 1 minute for rebuttal. Mr. Tordo, you have 3 and 1 minute for rebuttal. Mr. DiStefano, you have 3 and 1 minute for rebuttal. And Mr. Isaac, you have 5 minutes.
Thank you, Your Honor.
Thank you, Your Honor.
People versus Marquis Carter.
Good afternoon, Your Honor. This is Taylor Poore with the Office of the Appellate Defender for Mr. Carter.
Good afternoon. This is ADA Emily Aldridge from the Office of Darcel Clark.
And the appellant, you have 3 and 1 for argument, and the respondent has 3 minutes for argument.
Thank you.
Welcome. Underwood versus Urban Homesteading.
Good afternoon, Your Honor. This is Remy Green from Cohen and Green for the appellants.
Good afternoon, Your Honor. Quaker Minadonko from Gordon and Reese on behalf of the UHAB respondents.
Good afternoon, Judge. Jeffrey Metz from Adam Lightman Bailey on behalf of the Dawson respondents.
Thank you. And Mix Green, you have 6 and 1 minute for rebuttal. Mr. Minadonko, you have 4 minutes, and Mr. Metz, you have 3 minutes for argument. The next 2 cases will be heard together. CUCS HDFC versus Ames.
Clifford Ames for respondent appellant.
We have a respondent. Mr. Slowick.
Yes, I'm sorry, Your Honor, I was muted. Christopher Slowick for petitioner's respondent, CUCS.
Okay, Mr. Ames, I see on the calendar that we gave you 7 minutes, or it's recorded as 7 minutes for both cases. In fact, what I allotted was 5 minutes for a primary argument and 2 minutes for rebuttal. If you want to take your time and reserve 2 minutes for rebuttal, I'll allow that. Otherwise, in view of our mistake, I will give you 7 minutes all at once. What's your preference?
5 and 2.
That will be fine. Mr. Slowick, you have 5 minutes.
Thank you, Your Honor.
People versus Santos is submitted. Northern Manhattan versus Civil Court.
Your Honor, for the petitioner appellant, Northern Manhattan, Tracy Beauchart from Rosenblum and Bianco. Good afternoon.
Good afternoon.
My name is Mindy Jang on behalf of respondents from counsel's office, from the Office of Court Administration.
All right, Mr. Beauchart, you have 4 minutes and 1 for rebuttal. Ms. Jang, you have 4 minutes.
Thank you.
Favaloro versus the Port Authority.
Good afternoon. Sorry. Good afternoon, Your Honor.
Parties. Let's start with the Port Authority. Go
Good
ahead.
afternoon. Good afternoon, Your Honor. Adam Kipnis from Braff, Harris, Seconic, and Maloof for the defendant, appellate, and respondent, Port Authority of New York and New Jersey.
Good afternoon, Your Honor. Dario Anthony Koenigo from the firm of Hoffman and Schweitzer for Mr. Favaloro, plaintiff, respondent, appellant.
Good afternoon, Chris Theobald of Shaw, Bomedy, Citron, and Spratt for defendants, respondents, appellants, Turner Construction, Halmar International, and 2 World Trade Center.
All right, Mr. Kipnis, you have 5 minutes and 2 for rebuttal. Mr. Threeball, you have 4 minutes and 1 minute for rebuttal. Mr. Chinigo, you have 4 minutes and 1 minute for rebuttal.
Thank you.
Thank you.
Singh versus City of New York is submitted. AEJ 534 versus DHCR is submitted. Storino versus New York University.
Ira Feinberg for Appellant New York University, Your Honor.
Good afternoon, Your Honor. Jacqueline Esposito from Price, Meese, Schulman, and Darminio for respondents. And I would like to introduce my colleague, attorney Karen Edler, a member of the Bar of the State of New Jersey who's been admitted pro hoc vice for this appeal. And I respectfully request that Ms. Edler be permitted to argue this appeal before this court on behalf of respondents.
All right, your application for pro hoc vice is granted. Mr. Feinberg, you have 10 minutes for argument. And Ms. Edler, you likewise have 10 minutes.
Your Honor,
Thank you.
Your Honor, could I reserve 2 minutes for rebuttal, please? So make it
You
8
may,
and 2.
so it would be 8 and 2. Ms. Edler, and we'll give you, well, I'll give you the same 10. Okay.
Thank you, Your Honor.
All right. Huguenot is submitted and the gap is submitted. All right, we'll hear the first case on the calendar, People versus Anonymous.
May it please the court, Ria Trivedi from the Law Office of Ronald L. Kuby for defendant appellant. In People versus Pichardo, the Court of Appeals was very clear. When a condition precedent to a defendant's bargain for benefit becomes a nullity, when a crucial inducement to a defendant's guilty plea becomes unfulfillable, a court may not presume that in the absence of that inducement, the defendant would have in fact pleaded guilty. The condition precedent to Anonymous's bargain for benefit in this case was imposition by a federal district court judge of a term of imprisonment of at least 11 years, to which his state promised sentence of 11 years was to run concurrently, such that the entire term of imprisonment could be served in federal custody. Yet, nothing in Anonymous's cooperation agreement entered into by Anonymous and the Bronx District Attorney's Office guaranteed this outcome. The promise that his 11-year state term of imprisonment could be served federally was, is, and will remain unfulfillable.
Counsel, I'm sorry, this is Justice Moulton. You concede that if the federal sentence went forward before the state court sentence, that would be fulfillable.
Your Honor, as a theoretical possibility, had Anonymous continued down the road that was set forth for him by the district attorney's office, yes, it is theoretically possible that he could have entered into a separate cooperation agreement. Separate agreements were contemplated by the parties in this case. He could have entered into a separate cooperation agreement with federal authorities. They could have secured his participation in that cooperation agreement by way of a guilty plea. then any number of things could have happened. He could have cooperated for years to their satisfaction, such that they ultimately didn't seek a conviction, allowed him to withdraw his plea and dismiss the charges. They could have secured his cooperation by a guilty plea to an E or a D felony, which in the federal system carries a maximum possible term of imprisonment of less than 11 years, which would leave him sentenced to something less than 11 years, which would mean that his state term of imprisonment would ultimately run out in federal custody, leaving him to be returned to the state system. So while Your Honor is correct that as a theoretical possibility, if federal authorities had secured his plea by a C, B, or A felony in the federal system, pursued a conviction, gone in front of a federal district court judge for sentencing, asked that judge for a term of imprisonment of longer than 11 years, had that judge actually imposed that term of 11 years, had the Bureau of Prisons assume primary custody over Anonymous, and then have him return to the state system for imposition of his 11-year sentence, yes, under those circumstances, if every box was checked, the promises made to him by the Bronx District Attorney's Office, we would all look back on that and say, yes, that was fulfilled.
But all those contingencies were, or could have been known to the defendant at the time he entered the plea agreement.
Your Honor, nothing in the plea allocution, nothing in the cooperation agreement makes that clear. There is no discussion of the terms of the separate agreement to which he would enter with federal authorities. No promises were made about at the very minimum, the state of New York relinquishing primary custody over him, which is a crucial part of the Bureau of Prisons assuming custody over someone who's been arrested first by state authorities. So fundamentally, Your Honor, plea bargaining is not a thing of possibilities, it's a thing of promises. And what was promised to Anonymous was that his 11-year state term of imprisonment would be served in a federal facility. But none of that was fulfillable, was enforceable within the terms of the agreement that was made between him and the Bronx District Attorney's Office. And Pichardo is clear that when an agreement is unenforceable, whether it becomes an unenforceable later or it's unenforceable from the start, which I think is a circumstance not directly contemplated by the Court of Appeals, because the Court of Appeals hasn't contemplated a situation this extreme where a defendant's guilty plea is secured based on promises that nobody has written down anywhere, that involve parties in an utterly sovereign, separate system, that involve a federal district court judge, the U.S. Attorney's Office, the Bureau of Prisons, the New York State Department of Corrections and Community Supervision, and the Bronx District Attorney's Office. Here is a very narrow agreement between Anonymous, the Bronx District Attorney's Office, and the court. And I would point out that even the plea allocution, the reading of the cooperation agreement into the record features some degree of haphazardness. The promise that my client would serve his 11-year sentence was added orally after a bench conference. It does not appear in the actual written terms of the cooperation agreement, which I think corroborates the notion that this wasn't fully thought through. And had the parties thought it through, there was a way to secure this. The argument is not that this is never possible, that one can never enter into a cooperation agreement with state authorities and have their time served federally. It's absolutely possible. But it requires the direct participation of the U.S. Attorney's Office. It requires a clear relinquishment of primary custody by state authorities. And I believe it requires meticulous planning, which is to say an agreement with the U.S. Attorney's Office that they are going to secure a plea to at least a C felony. Because a C felony—
Counsel, let me interrupt you again, sorry. The plea agreement said that the state sentence would run concurrently with, quote, any, unquote, federal sentence imposed. Does that show the party's contemplation that there might not be a federal sentence at all?
Your Honor, the promises made to my client, the terms read into the record at the plea allocution were that his 11 years would be served in a federal facility. There was no ambiguity inserted into that provision. In order for his 11-year term of imprisonment to be served federally, a federal sentence would have to be imposed of at least 11 years. There's no way around that.
What does the word any mean there then? I know the quote I gave you was in reference to the concurrence of the two sentences, but doesn't any contemplate the possibility that there won't be a federal sentence, and therefore there won't be federal prison time?
Your Honor, that ambiguity wasn't inserted into the language about the term of imprisonment being served in a federal facility. I understand and am aware of the ambiguity that you're referencing with respect to any federal sentence that may be imposed or has been imposed. It appears that the court hadn't thought through whether they would be sentencing the defendant after federal authorities or before federal authorities. New York penal law makes clear that if a New York State sentence is to be imposed concurrent to anything, the other sentence has to be imposed first. So the ambiguity to which Your Honor refers, I understand, but it doesn't change the fact that my client was promised that his term of incarceration, with no ambiguity, would be served in a federal facility.
Right.
And that
you'll have time in rebuttal. You're way over your time. And I think has she answered your question, Judge Moulton?
Yes.
Thank you. Okay, let's hear from your adversary.
Good afternoon. May it please the court, Mary Ann Stracudano for the people. Your Honors, I just want to call your attention to the fact that the only remedy that's asked for by defendant at this time is a reduction of his term of imprisonment to 11 years. And the thing to remember about this case is that defendant committed heinous crimes, including breaking into a home, pistol whipping his victims, forcing his victims to strip down to their underwear, burning a victim with a knife, submerging another victim's head underwater, and forcing the victim at hand, the one who's on this complaint, to perform oral sex on him and probing her anus and vagina with his penis after she reported.
Well, I think that it's clear there were serious crimes that were asserted against him. But the question is really the enforceability of the plea agreement. Is there an unfulfillable promise? It's a legal question.
Sure.
So if you could answer that.
Of course. So to begin with, obviously, as we argued in our brief, this was not preserved. Any sort of claim regarding the inducement that my adversary claims happened here was a claim that should have been preserved, or at the very least could have been raised collaterally, right? Like as Justice Telmer argued over and over and over again, look, you can bring post-conviction motions. And even when she was speaking to defendant, she wasn't even contemplating the idea of the inducement of a cooperation agreement. So notwithstanding whether or not it's preserved, specifically, what we have in this case is a cooperation agreement with terms that are very common. And I'd like to call your Honor's attention to the briefs that I cited on page 47, the anonymous cases, Jenkins, Lopez, the idea that, you know, the district attorney had to determine whether or not cooperation was completed is a very common provision in a cooperation agreement. And specifically, the phrasing that occurred here, that the sentence will run concurrently to any sentence imposed in federal court. I mean, this language really reflects that the parties understood what was going to happen here, and that there was going to be a back and forth between the state cooperation and the federal cooperation. And then eventually he would be sentenced federally, and then it would come back to the state to be sentenced in state court. I mean, this is what happens all the time in countless cooperation. Sorry, was that? So this happens all of the time. And, you know, again, I'd like to call your Honor's attention to that case, People versus Vonneida, Vonneida. These terms are entirely enforceable. They're, you know, as a result, he waived his guilty plea knowingly, intelligently, and voluntarily. As we noted in our brief, there were countless times where the prosecutor and Judge Chalmer were saying, defendant knows exactly what he is doing. That is the exact language that is in the record over and over again. And let's not forget, he also waived his right to appeal. So for all of the reasons, the people believe that this court should not be disturbing his sentence. And I will defer to my brief unless your Honors have any further questions.
Do my colleagues have any questions? All right, we'll hear rebuttal.
I'll try to be brief, Your Honor. With respect to preservation, Your Honor, 90 days after entering his guilty plea, my client expressed profound mistrust for this plea agreement and for the attorney who represented him. From that moment on, nobody adequately represented him. No one adequately examined this plea agreement for enforceability. Nobody made the appropriate arguments. I'm sorry. The motion that was made was never adjudicated. by the court. The court continued to delay, claimed that the motion had been withdrawn, despite the fact that the attorney who made it made clear that he was not withdrawing the motion to withdraw the plea. Preservation completely, the preservation argument of the district attorney's office completely overlooks my client's ability as a layperson without a law degree to understand the agreement that he had been bound by. What he did do was express profound mistrust for it and communicate his desire to continue to cooperate once he understood that the agreement was in fact enforceable and he understood the terms to which he had agreed. The district attorney's office continues to insist that this happens all the time. The one third department case they cite for that proposition doesn't deal with these issues. The defendant in that case didn't challenge the enforceability of his plea agreement because all the promises that were made to him were kept. It did not happen in that case that the defendant mistrusted the plea agreement. In this case, he did, and with good reason, because it was unenforceable. And with respect to the waiver of appeal, Your Honor, this court has struck down waivers that deter defendants from filing notices of appeal, challenging the voluntariness of knowingness of their plea, which is a claim that distinctly cannot be waived given its constitutional gravity. So, that argument, it's very difficult for me to take that argument seriously given the utter unenforceability of the waiver, of the actual language of the waiver. And with respect to this claim being raised on 440, Your Honor, if this claim were brought on 440, it would be subject to mandatory dismissal. It's an on-the-record violation, and therefore the proper vehicle for raising it is on direct appeal, which is where we are today.
Thank you. Thank you both.
Thank you, Judge.
Thank you.
All right, the next case is Escobar against MRS. Mr. Cohn, you may proceed. Do we have you? Mr. Cohn?
Yes.
Okay, go ahead. I'm sorry, we can't hear you.
Let me see if I can you hear me now?
We can hear you now. Go ahead.
As the court is aware, the court below denied the plaintiff's motion for summary judgment under Labor Law Section 240 and granted summary judgment to the defendants. And I believe that the result should have been just the opposite, with summary judgment granted to the plaintiff, or alternatively, at the very least, the defendant's motion for summary judgment should have been denied. Preliminarily, although it's not dispositive, I think there's no question here, but this plaintiff was working at a height on a ladder. The ladder gave way, he fell, and he suffered an elevation-related injury. Now, the court said
isn't this case guided by the Court of Appeals case in Soto and the Soto factors for us to determine whether this is routine maintenance or cleaning under the labor law?
Yes, and I think if you look at those factors, I'd just like to point out one thing. One of the cases cited in our papers is Burnham versus Zilka. Existing work is held to be covered by Section 240. That plaintiff is doing the same thing this plaintiff would do. Now, as to the factors in this case, I don't believe there was any basis for saying it's routine work. As far as routine, regular work, the plaintiff's testimony was that he worked in the basement of this facility preparing fruits and vegetables. That had nothing to do with the use of a ladder or with the special brush he was given. He was asked, how often prior to the time of the accident had you been asked to do the type of work he was doing at that time on a ladder? And he said that was the first and only time he'd been asked to do that work.
Counsel, this is Justice Gonzalez. So I'm not clear. You're talking about a special brush and you're characterizing it as specialized equipment.
Well, I'm special
isn't it merely a 10-inch bristle brush that's screwed onto a wooden pole?
Well, in terms of what he regularly did, it would be something he wouldn't use. I mean, But it's what he was doing certainly didn't involve
But the
a ladder.
plaintiff, but how does this really differ from regular maintenance? It snows, like it's snowing a little bit today, and you have to clean the snow. How is this cleaning within the meaning of the labor law?
Two respects. First of all, as I say, in terms of what the evidence is, he never did it before. There's no evidence that his co-employees ever did it. Now, the judge said, well, certain things are done as a matter of routine. I agree that certain things are done as a matter of routine. Light bulbs routinely burn out and are routinely replaced. Shelves are routinely dusted. I believe that was a situation in the Soto case. But there's nothing in this record, for example, how often did it snow? When it snowed, how much did it snow? Did this sign ever have to be cleaned? That is an assumption. And, I believe that when you have someone who's working in an elevation, suffered an elevation-related injury, he should not be ruled out of court on what is essentially an assumption, because there is nothing, as I say, in this record. We know it snows, but how heavy is the snow? How often does something have to be cleaned? There's no evidence that that sign ever had to be cleaned. There's no evidence that was ever done. So there's no basis for characterizing this as a routine. When you have an injury under these circumstances, the man shouldn't be ruled out of court on what, as I say, is an assumption.
Wait a second, counsel. This is Judge Scarpula. Are you saying that because it doesn't snow in 2019, that means snow removal isn't a routine thing that a person who owns a storefront is required to do? That makes no sense to me.
Well, Your Honor, if it snows, you may be required as a routine measure to shovel the street.
And clean off the front of your place, right?
Not necessarily. There's no indication. There's nothing here indicating, let's say he had to do it because this was a problem for customers. There's nothing indicating that every time it snowed or every time it snowed, even when it snowed heavily, that this sign had to be cleaned off. You don't have to do that for customers to get to the store.
Counsel, are you saying to me that if for 1 year it doesn't rain or snow, and for that reason that event doesn't occur, for that reason, then it becomes non-regular maintenance or regular cleaning?
I would add one factor. If there's no indication that it had to be done every time it snowed, as I say, if it snows, even if it accumulates some amount of snow, you have to clear the sidewalk. But that doesn't mean you have to clear the sign. There's nothing indicating that if it did snow, the sign presented a problem. So that is what I'm saying is not routine. Now, if there was a question, if the court felt that if this court feels that the evidence is insufficient because we don't have any information that this was done whenever it snowed, then at the very least, the court should have withheld judgment on that issue and should have denied, it felt it had to deny the plaintiff's motion, should also have denied the cross motion so that the issue could be resolved, perhaps at trial when there's further evidence. But right now, what we have is strictly an assumption.
All right, we understand your argument. We'll hear from you on rebuttal. Mr. Kaminska?
Kaminska, yes, Your Honor.
Kaminska, go ahead.
Thank you, Your Honor. Glenn Kaminska with Amity Demers McManus, counsel for the defendant respondents. We would ask this court to respectfully affirm the decision of the Supreme Court, essentially for the very reasons set forth in Judge Rodriguez's decision. Here we have a plaintiff involved in a routine activity unrelated to any kind of ongoing construction, and it falls outside of the labor law.
Counsel, this is Justice Moulton. I'm sorry to interrupt you. The third department and the fourth department have found to the contrary, correct?
No, I don't think in this kind of case that they have found that this would fall within the...
What's different about the facts of Venom, which is cited?
Well, in Venom, cited by the plaintiff in the reply brief, involved the removal of snow, to be sure, but the court noted that this was for the purposes of enhancing the value of the property, improving the conditions of the property, and the plaintiff was specifically hired for that task at bar. That's different than what we have here, which is a routine event that could occur anytime there is a snowfall in New York, as Judge Rodriguez noted. The standard is
Burns. How about Burns, the Fourth Department case? How do you distinguish that? I don't know if that was cited by the plaintiff.
You know what? I can't tell you. If you give me the facts of Burns, I will distinguish that for you. But
that's your job.
It's an interesting approach.
No, it's basically, Burns also finds that the removal of snow and ice from a commercial building constitute a form of cleaning under the labor law, under the schedule.
Right, but we've seen that. But what you see in those cases are factors that are, when you apply SOTO, the SOTO factors, you see something that's different. Even what we saw in the plaintiff looked to our Berardi case, and we cited Berardi in our brief, and he looked to the Chavez case cited within Berardi. But there's also Garcia, which is a snow removal case from the Second Department, in which 240 it was not found.
Counsel, your adversary posits that discovery is necessary because it's unclear whether the cleaning of the sign was routine maintenance or not. Is this important to our analysis?
No, I think under the facts of this case and under the case law, just like Berardi, just like as the Judge Rodriguez here said, this is an activity that could occur anytime it snows. All right, but if it doesn't snow, as the panel had indicated, if it doesn't snow in 2019, but it does in 2020, it didn't make it an unroutine matter. If you look at Berardi, there's no indication of how often they remove the leaves from the gutters. Would this case be any different if this was a brand new building built for the first time during the first snowstorm this happened? This would still be a routine activity because it's the kind of activity that any homeowner could perform at their own home. So we're applying the four factors. We see it's routine. We see there's no specialized tool. He's using a 2-foot brush on a ladder. It's not like the case that three members of this panel decided just over a month ago in Ixcoy versus Pavlu, where 240 was determined.
This is Judge Gish. But that wasn't a snow cleaning case. That involved cleaning a particular piece of equipment by an outside company that happened to be located on the roof.
Well, it was, but you applied the SOTO factors, and that's what we're doing here. We're applying SOTO, and in that case, you noted the height, but you noted the special tools, the pressurized hose, the chemicals, and the fact that the plaintiff had specific training to perform that task. Here, none of that's present. The only SOTO factor that runs in favor of the plaintiff is the possibility that the height of this event was more than what might happen in a domestic household. And other than that, and the court acknowledged that and said, applying SOTO, this is not 240. And that's what the decision of this court should be.
Thank you. We'll hear rebuttal from Mr. Cohn.
Yes, briefly. Well, in terms of routine, I mean, one of the things I believe the plaintiff testified to was that he had been asked to clear the sidewalk before. And he'd never been asked to do this before. And I think the comparison gives some indication that what he was doing at the time on the ladder was not routine. Again, there is a lack of evidence here because
Counsel, are you
the snow had to be cleaned.
Mr. Cohen, are you arguing that if a person doesn't routinely do that work, it is not routine work?
First, you have to make the first step to say it is routine work. I don't think it's proper to start from the assumption there's no showing that this sign or a similar sign would have to be cleaned on any regular basis or would ever have to be cleaned. We don't know why he was asked to do it on that occasion. That's an assumption. So why rule a man out of court on what is essentially an assumption? Because, as I say, we know he was working at a height. He suffered an elevation-related injury because the ladder wasn't secured, and there's just evidence that's lacking here. And it might be that a court looking at this could say, well, maybe yes, maybe no, maybe it's routine, maybe it's not. But if it's a maybe, then summary judgment should not have been granted. And if the court feels that there was not enough to grant the plaintiff's motion, then the defendant's cross motion should have been denied, and the plaintiff should have been given his opportunity in court, pending the receipt of further information as to what a sign of this type required. Would it have to be cleared at all?
Thank you.
We did it for a commercial purpose.
Thank you. Thank you both. Okay, let's hear from Nanan versus Stephen L.
Yes, Your Honor, Jason Advocate. Your Honor, may it please the court. Appellant appeals from the dismissal of his downward modification petition. What makes this particular downward modification petition unique is both the length of time that this case dragged on for and the particular facts in this situation. Many of the facts on this case are not in dispute. It's not disputed that for much of the appellant's life, he was a drug addict. He was in and out of rehab centers, and he was living on the streets at times and in homeless shelters for a good portion of the time. At the time that the support order in this case was entered, he was in Florida. He had been kicked out of a rehab center. He was living in a Salvation Army center.
Excuse me, Mr. Advocate,
Yes.
as difficult as his life may have been at that time, we can't look at that first order. We can't. We're looking at the modification.
Correct.
The first order was entered on default, and however procedurally it went, and it was fought, and you tried to reopen it, it's binding. There's no reason to go back to that history. But we do go back to the date when he filed his modification petition, which was a year later. So why don't we work from there?
Although I would say, Judge, that even for that, there is a valid basis for a downward modification. The original order was entered in March of 2012. That would have been based on 2011's income at the time. His 2011 income showed $90,000 of income, which was the result of stock sales. He had liquidated his assets at that period of time. And then for when he filed his application in 2013, both for 2013 and 2012, his income had gone down to zero. He was earning absolutely nothing. So he had a virtually 100% decrease in his income. So you're right.
Part of this case is really based upon imputed income, because regardless of whether he showed income on his income tax returns, in terms of the life that he was able to live mostly during this extended period of time, he had family support. And isn't that money that can be imputed to him under the DRL?
Yes, first of all, yes, it could be, Your Honor. And it's rather typical that in many cases, judges will impute income. But I think on two things here. First, it's a bit of a double standard to say, listen, we should look at his support close to the date of trial, but we shouldn't look at any of the means or anything that happened to him in the 7 or 8 years that had gone before. He had filed a case for a downward modification.
Counsel, if I may.
Yes, Your Honor.
How much money did he realize? What was his gain from the sale of the Michigan house?
I don't know, Judge.
Well, we don't either, do we?
I don't know. It was not raised. It was not addressed at the underlying trial, and I think that to a large degree, it wasn't proceeded far enough because there was already evidence on the contempt side, and that went more to the downward modification. So,
and he had a trust.
Well, not exactly. The proceeds of sale of the house, the attorney who handled it, after initially giving him $15,000 and he ended up relapsing, basically held the money for him and doled it out to him in in drips and drabs. It's not the traditional trust that we think of, where a parent has set aside $1 million for a party. This is a different situation. The lawyer didn't trust him with getting the funds, and rightfully so. And sometimes lawyers actually do the ethical thing, and they take care of their clients.
We know that child support goes to assist the child, and the best interests of the child are paramount. Under those circumstances, why isn't imputed income part of the equation? This is a drug. The parties agree that this is a drug addict, but this is a drug addict who fortunately has a family that's been supporting him in so many ways. Why can't that income be taken into account, especially when we're talking about arrears?
It can, and it should. However, the court didn't assess how much it was imputing to him. It said, we will impute some income to him, but they set no amount. They didn't explore it at all, and they said that there's nothing in there to say, what are they imputing to him? Are they imputing a minimum wage job, or are they imputing a salary as a doctor? Are they imputing the income that they're paying for rent for him, or is it just the dollars they give him, which is about $3,000 a month for him to live off of? It's completely open-ended. I have no idea how much they're imputing. It is proper to impute money, but there's no sense of what they're imputing here. And also,
all right,
the money
Mr. Advocate, you're out of time, so I'm going to ask you to hold that until your rebuttal.
Thank you, Your Honor.
All right.
Thank you, Your Honor. Renee Katawala from Orrick, Harrington, and Sutcliffe for the respondent, Nanan. My client respectfully requests that this court affirm the family court's decision to deny appellant's downward modification petition. In order to gain reversal, appellant needs to show either that the family court applied the incorrect legal standard, or that the family court erroneously failed to consider evidence of relevant facts and circumstances. Appellant fails on both counts. Appellant cannot make the requisite showing because the family court applied the correct legal standard, as was just discussed. The standard is a substantial change of circumstances from the time of entry of the support order until the appellant filed the modification petition. The argument that somehow because this case lasted 8 years means that the evidence for that entire period of time is relevant is just unsupported in the law. The family court properly found that appellant had not shown a substantial change in circumstances during the relevant time frame. And I think the questions that Justice Gonzalez asked about income, which I'll get to a little bit in a second here, are very relevant here, though, because we don't know what the financial circumstances of this appellant was or is. His financial disclosure is vague and ambiguous. He leaves out information. The nature of the trust, completely unspecified. The tax returns that he submitted don't have a Schedule K, which would be expected if he was the beneficiary of a trust, which, regardless of the type of the trust. As was discussed, the sale of the home or the value of the home never disclosed. So there's just all of these financial questions that demonstrate that a party who fails to credibly and clearly disclose his or her financial circumstances, that fact alone bars his downward modification petition.
Right, and just, this is Judge Gish, just to clarify that would have been his burden to come forward. It's not just that the record wasn't developed on the Michigan House. He's seeking a modification in terms of his disclosure, would have had to disclose that information.
That is absolutely
It's
correct.
true financial circumstances.
The burden rests entirely on the petitioner, in this case, the modification case, and he utterly failed to provide any credible evidence that he was entitled to a downward modification petition. In fact, the argument of this imputed income, they don't know what income was used for imputation purposes, is belied by the record. The father here, Stephen, testified very clearly about the full sources of income that his parents gave him. Monthly payments of upwards of $4,500 per month, a psychiatrist, lawyers, a vocational coach, everything. The total amount per month that he received exceeded $18,000 per month. So there's absolutely no basis for the claim that somehow we're in the dark about what was imputed. The law very precisely says what may be imputed, and the court correctly imputed all of those incomes to say not only are you willful in your failure to provide support, but you don't, because of your inability to be clear about your finances, get the relief you're seeking, which is a downward modification petition. And I think the chronology here is critical. The order of support was issued in March 2012. My client filed a violation petition in December 2012. Interestingly, this father didn't appeal the willfulness finding. The willfulness finding, as the family court correctly held, prevented this father from proving his modification petition on those facts. In fact, the father admitted at the hearings that he had sufficient funds in trust to pay support at the time the order of support was entered and for some time thereafter. According to the father, his financial circumstances did not change until 2015. Therefore, this notion that he's a drug addict and he's somehow near homeless is belied by his own testimony, which shows he was doing very well, living off a trust, not paying any child support for more than 2 years, if you believe his testimony, which is frankly incredible.
I'm going to ask you to wrap up your argument because your time has elapsed.
Okay. Thank you, Your Honor.
Okay. Rebuttal?
Your Honor, let me address some of the issues there. First of all, the question of what documents he put into the record, and it was his burden, he attempted to put in an updated financial disclosure affidavit to which the petitioner's counsel objected, said that's for the downward modification. That's not an issue for the contempt. And he was prevented on the record from putting in additional financial information because the record is...
Let me ask you a question because
Yes.
it's very confusing to me. You would have had to fill out a financial disclosure form before you got to any kind of hearing, right?
Yes, he did one at the very start of the case.
And did that financial disclosure form indicate the value of the trust or the Michigan home or any of those assets that are being discussed? I mean, that would have been, that's required in any kind of proceeding like this, right?
Yeah, Judge, at that moment in time, there was no trust and the Michigan house had not been sold.
At what point in time are we talking about?
Sorry, at the time of at the start of the case. The case for the downward modification.
Michigan house. If there was no trust, there was a Michigan house, right?
Yes, correct.
And it had value, right?
Yes.
And was that value in the financial disclosure form?
I do not recall whether it was on the form, and I don't recall either whether the form has a place for that. It's mostly expenses and assets. I don't remember.
Well, you wouldn't consider a house an asset?
No, usually.
Let me just say to you, I do know it'd be accounted for on that form. Absolutely.
The old FDA forms weren't always clear on that, if I remember correctly, in family court. They've updated them now, and they're very good, but I seem to remember
that.
Oh,
no, they were always like that. I'm sorry.
But I don't remember, Your Honor, right now whether it has that house on it or not. But I will say that a lot of these issues would have been addressed had he been allowed to have a downward modification trial. The magistrate was very clear that he said repeatedly, and in the decision in the case, it says that you don't get to a downward modification if there's a willfulness finding. And that's the crux of it. And that's what the magistrate had said for quite some time, and it's in his final decision. So because of the willfulness, you don't get to that. And that's not the law of this court. That has never been the law.
Well, it can be if the issues are identical, but we have your briefs.
Your Honor, can I just say one thing, if that's at all possible?
No, you're out of time.
Thank you.
But we have your briefs, and you've discussed that point, so we know what your argument is. Thank you. Okay, Jekka versus Iron Horse.
Good afternoon, Your Honors.
And the first, Mr. Chang, you're going to be the first arguer here.
Sure. Thank you, Your Honors. May it please the Honorable Court, Your Honors. The thrust of our argument is that the 95% jury award of liability against 108-110 must be vacated, and upon such vacatur, 108-110 respectfully submits that a judgment of common law indemnification should be entered in our client's favor against the co-defendants, Iron Horse Transport, Michael Bush, and Resteel. In particular, Your Honors, the 95% award we respectfully submit was prompted by jury interrogatories on the verdict sheet that constituted reversible error by the Supreme Court, and in particular, which were in direct contravention of this honorable court's prior June 2017 decision that had resolved all issues of liability as to our client and was essentially law of the case. The Supreme Court, during the course of this trial, which occurred between May the 2nd of 2018 and June the 26th of 2018, at pretty much near the start of the trial, the Supreme Court was made aware of this honorable court's 2017 decision. In the proposed verdict sheets and requests to charge that were submitted, none of the parties requested any interrogatories as to 108-110, which clearly demonstrates that all parties knew that the inclusion of such interrogatories would constitute reversible error. Nevertheless, the Supreme Court still included jury interrogatories numbers 5 and 6, which are at issue, which requested that the jury make a finding as to negligence that was already determined by this honorable court, and they incorrectly requested that the jury make a finding as to apportionment of fault, again, in direct contravention of the 2017 decision. I should also point out, Your Honor, that in addition to that, the lower courts, the Supreme Court's errors were further compounded by the fact that upon charging the jury, the lower court, without any prior notice to the parties, charged them on industrial code violations. And again, the 2017 decision from this honorable court had already resolved issues concerning Labor Law 241-6. So in a nutshell, Your Honor, 108-110, it should never have even appeared on that verdict sheet to begin with. In the 2017 decision, as this honorable court knows, the claims by the plaintiff based on Labor Law 200 were dismissed against 108-110. The cross claims for indemnity and contribution by Iron Horse and Bush against our client were also dismissed. And while the plaintiff was granted summary judgment on Labor Law 240 and Labor Law 241-6, the decision also held that the liability of 108-110 was essentially passive and vicarious at best. So in light of the 2017 decision, which held that 108-110's liability was vicarious at most, and in light of what was the jury's correct award of 5% active fault against the
I'm
motor
sorry
vehicle.
to interrupt you, but I have just one question.
Sure,
Did
please.
your client have a common law indemnity claim against the other defendants asserted in this case?
Yes, we did. In the answers, I believe there were cross claims asserted.
You believe it or you know it, because that would be because that would affect what you are asking for in terms of relief, even if you're right. If there's no claim there, then you just add a lot. Then, quite frankly, the 95% looks better than 100% vicarious.
I do have that cross claims were contained in the answer to the, I believe it was the amended complaint, Your Honors.
Yeah, I would think that would be pretty essential. Okay, thank you. All right, let's hear from Iron Horse, Mr. Torto.
Thank you, Your Honor. Our first position is that the trial court committed reversible error in granting the plaintiff's motion in limine to preclude evidence of the plaintiff's comparative fault. It's our position that this was not a motion in limine, but a motion in effect for partial summary judgment on liability. It was untimely and improper, and under this court's decisions in Castellini and Downtown Art, a tactic that was akin to an ambush. Whether or not the plaintiff was guilty of comparative negligence was an affirmative defense that was raised in Iron Horse's answer and then we were entitled to present evidence during the course of the trial as to the plaintiff's comparative fault. There was the trial court's conclusion that there was no evidence as a matter of law that the plaintiff was negligent was improper. The trial hadn't even started. So on what basis could the judge make that determination?
The court, this is Judge Gish, the court can make a directed verdict if there's no facts that would otherwise support comparative fault. So what were you putting before the jury on that issue?
Well, as it turned out, Your Honor, during the course of the trial, substantial evidence of the plaintiff's comparative fault was adduced, and that included positioning himself too close to the double yellow line and moving traffic, and to the excavation trench in question. He was approximately 2.5 to 3 feet away from the traffic cones that he set, positioned himself with his
he was
back
2.5. Counsel, I'm sorry to interrupt. He was 2.5 to 3 feet within the area demarcated by the cones, I thought,
correct.
Unless I'm mistaken.
Right.
So in other words, he's in the area where he's supposed to be.
I don't know if he should have been in that area, Your Honor. He should have been, according to OSHA guidelines, at the front of the diversion lane, not in the middle. He positioned himself with his back to the traffic, and according to Bush's testimony, he was directing the backhoe operator where to dig, instead of facing the ongoing eastbound traffic on 116th Street. He failed to stand at the beginning of the traffic diversion lane, and he was in the middle thereof. He failed to follow OSHA guidelines. He failed to pay proper attention. He ran, we tried to escape the truck and fell into the trench. There's substantial evidence of the plaintiff's negligence. This was a close case, Your Honor, and had the jury been allowed to hear, had the jury been charged with a comparative negligence charge, the Iron Horse defendants may very well have escaped 100% of any liability.
Well, Iron Horse, was it responsible for the 241? I mean the 240 violations?
No, that's strictly on the owner.
Were there cross claims against it by the owner?
Yes, the owner did interpose a cross claim for common law indemnification against the Iron Horse defendants, and I'll get to that in a moment. But during the summation, we cited in our brief, the plaintiff's attorney hammered away at the fact that, as a matter of law, this is a quote, the judge has already ruled that there's no proof on the issue of any negligence on behalf of Mr. Jecka, that there's, quote, no issue of what Mr. Jecka did or didn't do that contributed to his accident, and that whether plaintiff set the cones up improperly or was not in charge or in charge of doing so are all irrelevant.
But counsel, I'm kind of lost, because the truck driver, Mr. Bosch, himself admitted that the plaintiff was standing within the cones when Mr. Bosch hit the plaintiff with his truck. So you're saying that the fact is established by Mr. Bosch that the plaintiff was standing inside the cones establishes comparative fault? Is that what you're saying?
I'm saying that the fact that the plaintiff was standing inside the traffic cones between the double yellow line and the excavation trench, approximately 2.5 feet away from moving traffic, raises an issue of comparative negligence that was for the jury to resolve.
Okay, thank you.
Now,
Let's hear. You're out of time. You'll have rebuttal. Mr. DiStefano?
Yes, good afternoon, Your Honor. May it please the court, Anthony DiStefano for the defendant respondent appellant, Ray Steele. Just building on that, one of the things that my colleague did not get to say was that the cones that were set up for traffic to travel along East 116th Street were supposed to be 11 feet wide. And by plaintiff's own admission, the cones were not 11 feet wide. They were, in fact, closer to what Mr. Bush testified to, which was only 9 feet wide. And that made it significant because Mr. Bush was operating not only a tractor, but a very long trailer. And that trailer did not have the appropriate space to be able to move through the channel that it otherwise would have had had the cones been 11 feet apart. So the fact that Mr. Gajeka is standing in the middle of the excavation zone, again, as counsel said, very far from where he should have been standing, which was all the way back at the beginning of the cone diversion, in an area where the tractor trailer had to go back to the right towards Mr. Gajeka, and that allowed the trailer to potentially offload or off track into the zone where Mr. Gajeka was working, and that is what the theory of what caused this accident. Counsel also didn't get a chance to speak about damages. I'll just briefly touch on that. There was testimony here that Mr. Gajeka, although he was working before the accident, had very serious degeneration in his spine. Ultimately, what we have here is a diagnosis of one-level herniation, where there wasn't even surgery on the herniation itself. There was surgery on the bony process in the vertebrae adjacent to where the disc was herniated, and the surgery was to shave off the bony process. So it was a single-level herniation where the surgery was actually addressed to the arthritic condition in Mr. Gajeka's spine and not to the disc itself. And yet the jury awarded $1.5 million for past pain and suffering and $1.5 million for future pain and suffering. And under the analogous cases in 5501C, once that's applied here, and we compare similar cases such as the Hernandez case cited in our brief, the awards for pain and suffering should be reduced. Similarly, the awards for loss of consortium with regard to Mrs. Gajeka, here $1 million, 500 past and 500 future. Under analogous case law, those should be reduced as well. Mrs. Gajeka testified that she worked on the day of the accident. She continued to work after the accident. She probably continues to work to this day. Really, her life did not change very much. I'm not meaning to demean the significance of what happened here. I'm just saying that in comparison with other cases where $1 million plus awards were sustained, Mrs. Gajeka's comparable suffering here is much less. Talking about the indemnity issue, yes, there is a cross-claim against both the Iron Horse defendants and Ray Steele. Ray Steele is just the owner of the trailer. That's it. The testimony is that the trailer functioned as intended on the day of the accident, that there was nothing wrong with the operation of the trailer itself, and that this accident is the responsibility of how the trailer was operated by Mr. Bush. Mr. Bush is not an employee of Ray Steele. We did not train him. We did not supervise him. We merely own the trailer.
As a consequence of that, did there need to be an apportionment of liability where they apportioned percentages to Mr. Bush?
As between Mr. Bush and whoever else theoretically could have been on the verdict sheet, yes. Mr. Bush did need to have, because as to Mr. Bush, this was just another motor vehicle accident. This was not a labor law case. This was just an accident in the roadway, and whether or not Mr. Bush was negligent in the operation of his tractor. But as to Ray Steele, the owner of the trailer, who now under the VTL is vicariously responsible for Mr. Bush, that's it. We're only vicariously responsible. There is no active fault against Ray Steele. For that reason, 108-110's common law indemnity claim against us has to be dismissed. Remember, there's two conditions that need to be met for common law indemnity to apply. Number one, 108-110 has to be free from fault. Assuming this court does not revisit its earlier 2017 decision and it adheres to the finding that 108-110 is free from fault, then it's satisfied that condition. But the second condition is that the party from whom 108-110 is seeking indemnity must be negligent, must be actively at fault. And here, Ray Steele is not actively at fault. Ray Steele was not on the verdict sheet. Ray Steele actually asked for the court to tell the jury that Ray Steele was free from fault, which the court declined to do. But irrespective of that, there's no evidence whatsoever that Ray Steele was actively at fault. So for that reason, 108-110 has no direct claim against Ray Steele for common law indemnity.
All right, thank you.
Thank you.
All right, let's hear from the plaintiff.
Good afternoon, Your Honors. Brian Isaac. I represent the plaintiff respondent. I was the beneficiary of this court's prior decision in the Gajeka appeal, so I'd like to deal with that. But let me talk about comparative negligence first, just a little bit. I'd like to talk about damages as well. Some of the members of the court asked what the plaintiff did wrong, and the answer is nothing. It's undisputed, as far as I can tell, that plaintiff was within the safety zone. I would ask the court simply to look at 645 to 648 of the record and 820 to 821 of the record. I'm going to boggle this name. I'm sorry. Mr. Dembo Gaj, who was the plaintiff's supervisor, made absolutely certain, using his words, quote, "No one can get involved in the foreman's decision." Quote, Whatever the foreman says the worker has to do without considering whether it's good or bad. That day I had all the responsibility. And if you look at 646 and 820, when he was talking about responsibility, I think what he meant, because English wasn't his native language, was that Martin was in charge of the flagmen, but he was not in charge of placing the cones. With respect to the argument that the plaintiff should have had his attention focused just on the car, the tractor trailer that struck him, let me point out to you that the defendant's defense refutes itself, because their claim is that he was going 3 miles an hour, he was doing everything correctly, and that the reason the accident occurred was because the rear of the trailer, and the term they use is offloaded to the right. So there is no way that the plaintiff should have even known about this, because it wasn't a direct hit at all. And if you'll recall the testimony, which is also undisputed, there are 2 channeling lanes, and there's an excavation right next to where the plaintiff is standing. So the fact that he's not focusing his attention on one thing is reasonable. And under your decision in Paralysis against the city, potential claims which aren't proven don't establish comparative negligence. With respect to the issue of damages, let me say this. The plaintiff had an absolutely horrible result. He had tons of testimony from his treating physicians that it was absolutely a terrible result. There's testimony from Mr. Cash that he was subject to a spinal stimulator. The laminectomy failed. The plaintiff was an excellent worker. His own employer testified he was a great worker. He wanted him back. He would have hired him back if he was able to work. He's a real American success story. He came from a foreign country because he was oppressed. He got a green card. He paid taxes. He worked all the time. He had no symptomatology at all.
Counsel, if I may interrupt,
Sure.
Would you address the issue of future medical expenses and the failure to provide a 3101D expert disclosure notice to the other side with respect to the future medical expenses, please?
So, Justice Gonzalez, the argument is that Dr. Guy, who gave the expenses, was a treating physician. And as a general rule, as you know, under the Krinsky case going back 20 years, it's settled case law that you don't have to have a 3101D. I read over the first 220 pages of the record like you did to try to see if there was any claim in the post-trial motions that the defendants were unprepared to deal with Dr. Guy's testimony. They were not.
Mr. Isaac, this is Judge Scarpula. Was there anything in the treating physician's records about future medical care?
I believe that if you look at the medical records, Judge Scarpula, there was testimony.
I didn't see anything. So if you can point it out to me, let me know.
I don't think it's actually in the appendix, but I think that it was clear from the testimony of Dr. Auerbach.
I'm asking you whether in your exchange of documents, you gave the defendants any information by which they could see future medical expenses.
Well,
any information, any pieces of paper.
There was no formal 3101D and
anything in the doctor's medical records that indicated the cost and what kind of future medical care would be required.
No, I'm sorry, I didn't understand you. Dr. Guy was the conduit by which that testimony came in, and he did testify that he did not give a report. And
so there's nothing. They got nothing in discovery about future medical expenses, correct?
Correct, but they did have the.
So the fact that he is their treating doctor doesn't ameliorate the fact that they had no information about any of this prior to trial.
But the issue is, do they have sufficient information in terms of the overall medical to know that he will need?
I don't think that's the issue at all. I don't think the cases say that. I don't think anything, you can't point me to a single case that would say just generally in the air that something's going to happen in the future is sufficient notice of future medical care. I just wanted to make sure that we were on the same page, that there wasn't any paper discovery about that.
There was clearly no paper discovery with respect to that. I'd also just like to point
out that Mr. Isaac, your time is up.
I'm sorry, Your Honor.
Okay, no reason to apologize. Okay, Mr. Chang, 1 minute.
Yes, thank you, Your Honors. Just to address the points, just that Resteele made concerning indemnity, and just for Your Honor's reference, pages 100 to 106 of the record is our answer whereby the cross claims were asserted. But just to revisit the indemnity argument, Resteel claims that its liability was passive and vicarious. However, it's more than that, Your Honor. Section 388 of the Vehicle and Traffic Law says that when components of a vehicle, such as a tractor and trailer, are utilized in tandem or in tow or in combination, they are treated as one. So I don't think that Resteel can quite honestly sidestep its liability and claim that it is merely vicarious when it is actually jointly and severally liable. As to, just to finish off my argument about the indemnity, Your Honor, the reason why 108.110 is entitled to indemnity against the motor vehicle defendants is 108.110 has met its burden of establishing those two elements of common law indemnity stated by Mr. DiStefano. The prior 2017 decision establishes that 108.110's labor law liability is vicarious and passive, and the jury award of 5% fault against Iron Horse and Michael Bush is that active finding of active fault on their behalf and by operation of the VTL against Resteel Supply as well. Resteel Supply didn't have to be on the verdict sheet because their liability is not a question for a jury. It's under by operation of the VTL. So for those reasons, Your Honor, we respectfully submit again that the 95% award against 108.110 should be vacated, that an order for common law indemnity in our client's favor should be entered. And I thank Your Honors for your time and consideration for this matter. Thank you.
Thank you. Mr. Torto?
Thank you, Your Honor. With respect to the indemnification issue, it's the Iron Horse's position that as a matter of law, they did not breach any duty of care to the defendant building owner. We've cited cases in our brief which support the proposition that in order to obtain common law indemnification, the indemnitor, in this case the Iron Horse defendants, must owe a duty of care to the indemnity, in this case the building owner. The Iron Horse defendants did not breach any duty to the owner. The owner has been held liable in this case, not because of Iron Horse, but because they're held vicariously liable for the negligence of Express Plumbing, their contractor. That's where their liability is fastened. They weren't held liable because of Iron Horse, and therefore there's no trigger of common law indemnification as to Iron Horse. Every case that the owner has cited in their brief, they cite 6 cases. Every one of them involves a case where there's a relationship between the parties, usually based on contract. This case, there's no relationship and no basis for indemnification. Additionally, under these circumstances, it would be unfair to hoist 95% of the liability plus the 5 that the jury already found on the Iron Horse defendants. If you look at the 100% picture, you've got 5% that's allocated against Bush. The owner says that you can't allocate 95% against them. You can't allocate 95% against Express Plumbing because they're immune from liability under the workers' compensation law, and there's no grave injury. So that leaves only one possible party against whom the 95% could be allocated, and that's the plaintiff. And that's why it was critical that there be a charge of comparative negligence here. Had the jury heard that and been properly charged, there may have been a complete acquittal in favor of the Iron Horse defendants. And in view of the time, I'll rest in my brief for other points.
Mr. DiStefano?
Thank you, Your Honor. I want to just be very clear here that what we have is really 3 separate defendants. We have the building owner who hired a contractor to perform a sewer installation in the street, and that's a labor law case for which this court had already rendered a decision. The other 2 defendants are the owner and operator of a tractor, which is Iron Horse and Mr. Bush, and a trailer, Ray Steele, who they simply own the trailer. That has nothing to do with the construction that is going on that's being performed by 108.110. So as to them, this is purely a motor vehicle case. What Mr. Chang said was that under the VTL, Ray Steele, the owner of the trailer, becomes at fault for Mr. Bush's operation of the tractor. That's true, but that's purely statutory. And the Court of Appeals made clear in Morris versus Snappy Rental, 84 New York 2nd 21, that prior to the existence of VTL 388, there was no liability. So the imposition of VTL 388 liability is purely vicarious and purely statutory. So just like 108-110 is being held vicariously liable for its contractor, Express Plumbing, and the work that Express Plumbing was doing in the street, Ray Steele, the owner of the trailer, is being held vicariously liable for the operation of the trailer by the tractor driver, Mr. Bush. That, in and of itself, should defeat any claim over against Ray Steele by 108-110. Two purely passively, vicariously liable entities trying to get indemnity from each other has to fail under the well-established Court of Appeals precedent that requires there be a finding of active fault against against the proposed indemnitor.
Okay, thank you. Thank you all.
Thank you.
Thank you, Your Honors.
Thank you.
Okay, People versus Markey Carter.
Good afternoon, Your Honor. May it please the court, Taylor Poore with the Office of the Appellate Defender on behalf of Marquise Carter. The trial prosecutor in this case initially made an offer of 12 years in prison, knowing full well every detail of the extremely serious crime.
This is Judge Gish. That offer was made in exchange for certain cooperation. It was part of a plea negotiation that never came to be, correct?
Correct.
So why should he get the same benefit that was being offered as an incentive for cooperation as when he didn't provide the cooperation as what would be a just sentence for the crimes that he pled to?
So given that Mr. Carter was going to be spending the next decade of his life in prison, the extremely grave danger he would face if he did testify against his co-defendant meant that that 2-year discount in exchange for testifying was not a realistic option. So what that
So he made a decision and he said, no, I'm not going to take it. Instead, I would rather have the extra 2 years, but it wasn't a nothing plea. He didn't plead to the top count, which is significant here because his co-defendant got convicted of that count.
He also did, by pleading guilty immediately after hearings were complete, save the prosecutor and the court the cost and the time.
That's always the case in a plea.
Absolutely.
Right?
So I think what this offer of 12 years really represents was a recognition that, considering all the facts of the crime, 12 years did protect society's interests and was, according to the trial prosecutor who had all those facts before him, in this case her, was the right amount of time for Mr. Carter to spend in prison, given what he had done. And that's because that offer and that sentence balanced the seriousness of the crime against Mr. Carter's young age at the time.
So your argument, though, taken to its logical conclusion, is that every time a prosecutor offers a favorable sentence that the defendant can thereafter not be sentenced to anything more? That's not the law.
What in this particular case, this particular condition meant that Mr. Carter would be facing incredibly grave danger in prison after testifying against his co-defendant. And so I don't
see where that really factors into the issue about whether the sentence he received was excessive. I just don't understand that. That factors into whether he decided that it wasn't a good idea to take the plea, which, certainly I understand that. That was certainly an appropriate thing for him to balance. Sure.
If I could return to that in my rebuttal. I know that my time for argument is coming up, and
okay, that would be fine.
And I'd also love to address the appeal waiver.
You can address that on rebuttal as well. Thank you. Okay, let's hear from your adversary.
Emily Aldridge for the people. I will address the waiver really very briefly, since my adversary is going to bring it up in rebuttal. The waiver was valid. The proceedings were essentially identical to that in Bryant, which this court routinely cites in tandem with Thomas in upholding appellate waivers. And the sentence was appropriate for his role in causing Mr. Melendez's death. His co-defendant, as Judge Gish pointed out, received the maximum sentence of 25 to life for that role. And in that appeal, he also claimed that that sentence was excessive. And this court found no reason to lower that sentence. So if there are no questions, I rest on my brief.
Yeah, does the recent Court of Appeals case in People v. Bisano affect the validity of the waiver at all?
Your Honor, I'm sorry, I'm not familiar with that one off the top of my head right now, but
okay. Well, let me elaborate. Right, in that case, as I understand it, that a written in an oral colloquy in which the defendant is told that the waiver is an absolute bar to appeal and no issues survive, that's not valid. Does that apply here, where the trial judge actually indicated that nothing survived the waiver of appeal, although the written waiver did in fact identify the issues that survive?
Well, in this case, I would argue that that it was still a valid waiver because it was so clear that this was something that was thoroughly discussed between defendant and his counsel. This was not just a flippant.
Yeah, but what about the issue about whether anything survives a waiver of appeal? Was the defendant made aware of that in any way?
It was in the written waiver, and the extent of the conversations between defendant and his counsel would seem to indicate that he was
but you wouldn't know well that. You don't know what they discussed, honestly. You can't say that.
No,
you can't say it was in the written waiver.
Conversations, but given that the court went over, I don't have it in front of me, but 4 or 5 times just to confirm that defendant was clear on the waiver, would seem to go to its acceptance. And furthermore, again, the sentence was completely appropriate.
Okay. Thank you.
Thank you.
All right, rebuttal.
Thank you, Justice Gish. Just briefly, first of all, I think the trial prosecutor clearly saw this case as being worth 12 to 14 years, worth 12 years, that 12 years was enough time in prison. From Mr. Carter's perspective, that 12-year offer was not a real offer, given the danger that he would face. And so that is why, at this point, Mr. Carter's asking that the court reduce his sentence by 2 years to 12 years. Just to briefly address the appeal waiver, what Bissono and Thomas stand for is the proposition that there are these 2 threshold requirements for an appeal waiver, which is not only that the court distinguish between appeal rights and trial rights in a meaningful way, but also that the court not incorrectly inform the defendant, as Justice Gish just pointed out, that the appeal waiver completely forecloses any issues on appeal. And both the court failed in both of those ways in this colloquy, so we don't even need to get beyond that to consideration of the written waiver.
And in your view,
yes,
it doesn't matter that the written waiver was correct on those points.
Exactly, because the Court of Appeals has clarified that we need more than that. We need the court to actually discuss those 2 very basic implications on the record, in addition to whatever may be in the written waiver.
Okay.
So for all those reasons, unless the court has any further questions, again, we'd ask that the court reduce Mr. Carter's sentence by 2 years in keeping with the trial prosecutor's original offer. Thank you.
Thank you. Thank you both. Right. Underwood versus Urban Homestead.
Good afternoon, Your Honor. My name is Remy Green, representing the appellants. May it please the court. The court below dismissed the complaint in this case with 2 primary rationales. First, that the plaintiffs failed to allege any facts supporting a conclusion of agency. And second, that the plaintiffs failed to allege that any defendants had been enriched for the unjust enrichment claims. Unless I know that there are a couple other issues in the brief, but I'd like to focus on those 2 here at argument unless the court has questions. So first, it's well-settled law from this court that the New York Supreme Court applies routinely, that when the circumstances of a case or a set of allegations raise the issue of agency, but there's no written authority of agency, those questions, that question of whether or not somebody is acting as an agent is a fact question for the jury. It's not even resolvable on summary judgment after discovery. It's only resolvable at the jury. Here, I think the allegations that raise the issue of agency are fairly clear, and the court below didn't discuss them at all.
It would help if you elaborated somewhat here, because I didn't see any interaction with UHAB, any representations by UHAB or discussions with UHAB or writings by UHAB authorizing the Dawsons to act as an agent. Therefore, did they have authority, apparent authority, or were they simply acting on their own for whatever reason? Do we really know what the structure was at that building? Or who was in charge of the tenants?
Sorry, Judge Gonzalez, did not mean to speak over you.
Please.
The answer to that is, of course, we don't know the precise details of it, because that would never be accessible to a plaintiff in this position. What we do know is that and I think this falls under apparent.
I would beg to differ. Is there anything in the record that tells us what the relationship was between this plaintiff and UHAB, or the Dawsons and UHAB, as opposed to the understanding or the speculation that UHAB had authorized the Dawsons to speak on its behalf?
Well, I think that the fact in the record that is most important to that question, Judge, is that that Jeff Underwood called the relevant representative of UHAB who should be answering those questions, right? That's Metalios, who is the director of client interaction, or I think I've gotten that title slightly wrong. But that call was immediately returned by Isabel Dawson, and as the Dawson defendants put in their answer, at the direction of Metalios, she returned that call. And I think that's enough to get over a motion to dismiss and take more discovery on that question. And, you know, if the court has concerns about the scope of discovery, then maybe limited discovery.
That was a one-time occurrence, am I right?
I think that if this had been the issue, then perhaps the most appropriate thing to do would have been to dismiss without prejudice or something of that nature, because we could have easily filled out the pleading with more instances of the Dawsons acting on behalf of the building. They regularly communicated with the building, and I think on one of the other motion, or on I want to say on the B&N motion.
Judge Gish, the fact that the Dawsons communicated with the building doesn't make them their agents. I think for the apparent agency, you would have to have something from somebody from urban homesteading telling your clients, deal with the Dawsons. They're for me. And the Dawsons can't establish the agency.
Well, Your Honor, if I call...
Isn't that the law?
I don't think it is. I think that it comes from all the circumstances. So, for example,
this is Judge Scarpula. Yeah, that is the law. The person, there has to be something from the principal, not the agent, to at least allege an apparent agency. We all agree there's no specific agency. So only thing we're dealing with here is apparent. And it can't be from the person. I can't go out and say to you, I'm Joe's agent, and that be enough to convey it. It has to be from the person with whom you're trying. So what allegation is there from that entity, from the right? If you're saying to us, well, give me a chance to plead it.
No.
Well, my answer to you is, why didn't you plead it?
Of course not, Judge. And the answer to that is the apparent agency comes from returning a phone call that was directed at UHAB. And so, for example,
that's something that the principal did, right? That's something that the alleged agent did.
it has to involve conduct by the principal, though. So if I called Your Honor's chambers and left a voicemail and said, there is an emergency issue that I need the court to act on, and I got a call back from somebody saying, I've spoken to the judge.
But let me just stop you for a second. You didn't allege that those defendants said, I spoke to the principal. Here's what the principal said to me. And you
Judge, I think
went
we
back
did.
and said to the principal, did you say that? In which case, then that would have been a great allegation, but it's not there.
Well,
it can't be just the alleged agent. It has to be something that the principal actually did to foster that belief. And that's what I'm trying to say, that the fact that they called back has nothing to do with the principal.
To be clear, Judge,
I'm going to let you're over your time, but I'll let you respond to Judge Scarpula's last statement.
Right.
Of course. And to be clear, Judge, I think we did absolutely allege the first part, that they called and that the Dawson said, I have been told by UHAB you need to be out tomorrow. And I think that in that context, that you have to be out tomorrow and you are going to ruin this deal for everybody else, there was no time to call and confirm that. It was, you need to be out, and in the context of the squat buildings on the Lower East Side, right? This was a situation where people did fear that they would be thrown out of these buildings any day. And so that context, I think, is extraordinarily important. And to tell the Dawsons to convey that threat, I think, is enough to get to agency, or at least enough to survive a motion to dismiss on agency.
Okay, thank you. All right, let's hear from UHAB's attorney. Is UHAB's attorney online?
Sorry, Your Honor, I was muted.
Okay, unmute yourself. Go ahead.
As an initial matter, I am quite surprised to hear from appellant's counsel that the appellants alleged in the complaints, or rather that the Dawson defendants told the appellants that the Dawsons had been told by UHAB that the appellants had to leave in the building. Nowhere is that alleged in the complaint, and nowhere is that alleged in the Dawson defendants' answer. To be clear, nowhere in the complaint or anywhere in the record are the Dawsons alleged to have told the plaintiffs that the Dawsons were speaking at the behest of UHAB or on UHAB's behalf. And just to sort of touch upon or echo the question posed by Justice Gonzalez to appellant's counsel, and as has already been discussed, in order for apparent authority to be properly alleged, the plaintiff appellants would have to allege that there was some conduct directly by the UHAB defendants from which the appellants inferred that the Dawsons had apparent authority. And again, the complaint is woefully deficient in that respect. There are absolutely no allegations tying the alleged statements made by the...
And is it your position that even if the Dawsons called up in close proximity to a phone call made to UHAB, and they said, hey, we're acting for UHAB, that wouldn't even be enough? Well,
yes, that is my position. But I would just like to make clear that is not what is alleged. In none of the conversations cited or that are put in quotes in the complaint is it alleged that the Dawson defendants ever told the plaintiffs that they were essentially the voice for UHAB, or that they were directed by UHAB to convey certain information to the plaintiffs. The plaintiffs just simply unjustifiably relied upon what the Dawson defendants allegedly told.
By the way, if there were additional facts that the plaintiff knew or had that weren't necessarily in the complaint, they could have put them in an affidavit in response to a motion to dismiss in order to amplify the complaint. Could they not have?
Yes, Your Honor. Yes, Your Honor, and beyond
And
that.
they didn't.
Right, and in response to our motion to dismiss, they could have presumably cross-moved to amend the complaint. They chose not to do so. Rather, they chose to file a motion to re-argue the lower court's dismissal of the complaint, which was also denied. And because I'm not going to have a chance to do so, I presume that my colleague on the other side is going to address the unjustifiable enrichment claim, or just unjust enrichment, I'm sorry, claim. And on that point, the only thing that I would like to say is that to establish an unjust enrichment claim, the plaintiff must show that it is against equity and good conscience to permit the other party to retain what is sought to be recovered. Putting aside for a moment the nominee agreement between my client, the UHAD defendants, and the co-defendant who is not part of this appeal, but was dismissed in the lower court, BNN, which says that all proceeds from the sale of the apartment units in the building would go to BNN. Here, plaintiff cannot establish that it is against equity and good conscience when they had an opportunity to simply pick up the phone or make subsequent efforts to confirm from UHAB whether they were required to leave the building and chose not to do so. Rather, they just merely decided to rely upon these alleged statements made to them by their fellow tenants.
Okay. My colleagues have any further questions? All right, we'll hear from Mr. Metz now.
Afternoon, Your Honors. My position is pretty simple. The appeal, the order was dismissed. Originally, they moved for re-argument. Re-argument was granted, and then on the basis of that cross motion, the complaint against my clients were dismissed. Our brief argues that this order is moot and it's been superseded by the re-argument order. Counsel for the appellants agrees. We have put in argument with respect to the second order, asking if the court wanted to view that under 5517B. But
well, isn't there, Mr. Metz, this is a procedural question. Don't you have an appeal pending from the re-argument or no? Or excuse me, doesn't the plaintiff have an appeal pending from the re-argument?
Well, listen, they say that I believe they filed the notice of appeal, but there's been no perfected appeal with respect to the re-argument order as of yet.
So I guess my concern would be that if you're right, and I think procedurally you probably are right, that the re-argument moots it as to your client, then if we were to get to the merits on this order, it would be in effect an advisory ruling on an appeal that hasn't been perfected. Why would we do that?
Your Honor, it's belt and suspenders. When the re-argument was made, and it was granted and the dismissal was vacated, we asked opposing counsel to withdraw the appeal as against us. It did not occur, so we had to put in a brief. And that was the point.
No, I'm not faulting you. I'm just trying to understand what the consequences of this procedural stuff is.
No, I understand that. And I'm not looking to take any unfair advantage because in the appellant's reply brief, they just basically said that it should be dismissed as against us and did not address the merits of the re-argument motion. So I'm content to abide the event if they ever do perfect the re-argument to deal with it at that point in time.
Okay. All right, Ms. Green.
Thank you, Judge. Yes. If I may briefly just respond to Mr. Metz, I think there may have been some miscommunication because we would have withdrawn it. But I think the timing was all.
You could withdraw it in front of us.
Great, done.
In our order.
Done. We're done.
That makes sense. Everybody's agreeing. Why are we writing on this? I think do you agree, counsel, to withdraw?
Yes, absolutely. It's moot. There's no question it's moot. So with that, and let me move to, as my friend previewed, I'm definitely going to talk about unjust enrichment because the unjust enrichment claim does not require agency, right? The wrongful act could be, even without it establishing agency, the direction that I think everyone admits happens, and this is record 62, paragraph 32, that Isabel Dawson spoke with a representative of UHAB and relayed the substance of that conversation. And that's in response to the allegation of the content of that conversation. And so for unjust enrichment, I think the only element that to me seems to be in dispute is this argument about the nominee agreement. And I think that's just wrong, especially at a motion to dismiss stage. We have government records that carry a criminal penalty for false statements in them, filed on ACRIS by UHAB HDFC, reflecting hundreds of thousands of dollars of benefits. Right, the argument made in the brief, at least, was that the reason unjust enrichment fails is because there's no enrichment, but there's absolutely enrichment. There are unquestioned.
Help me here. So you have an agreement that says UHAB HDFC is going to hold title for a period of time, but UHAB is not going to keep the proceeds or reap any benefits, and everything's going to go to BNN. We keep nothing. So if you have that kind of document in place, don't you need something to refute the document in some way and show, oh, but look, this money did go this way? If the agreement says we're going to receive the money and turn it over, don't you need more than an allegation that the nominee agreement is a farce?
Well, to be clear, the nominee agreement is beyond the four corners of the complaint, right? It's something they brought in, but I'm seeing shaking heads, so I'm not going to go that direction.
Well, because on a 3211A1 or the motion, right, documentary evidence, or an ad 3212 motion or on a motion to dismiss, 3211A1 says you can put a document in front of us that refutes the claim. And I think Judge Gonzalez is saying, why doesn't that document refute the claim?
So I'll go there, which is on ACRIS, there's a later signed contract that says the exact opposite, that says that BNN gives UHAB HDFC all of the profits from it. But I think ultimately the point is it doesn't matter if you've signed it, because unquestionably they got hundreds of thousands of dollars. They signed a contract and presumably just time shifted the benefits, right? I don't think that you can avoid ever having unjust enrichment liability by agreeing that you pay us $100,000 now, and we'll pay it when we get paid, we'll then give that to you. And you know, real estate prices fluctuate, but they're not that hard to predict in some real sense. So we have a contract here where they've just time shifted the benefits, and what form those took, I don't know. But it's not as if they weren't paid $100,000 something for each of these units. They are. We know they were. And so whether the way they benefited from that was directly from the money or from the consideration they received for selling that benefit, either way they benefited.
Good. All right. Thank you. Thank you all.
Thank you, Your Honor.
Thank you, Your Honor.
Okay, CUCS HDFC against Mr. Clifford Ames. All right, Mr. Ames, I'm going to give you 5 minutes and 2 on rebuttal for both appeals together.
Court, respondent appellant Clifford Ames. The trial court's decision that appellant Ames lacks standing for his zoning resolution allegations against CUCS was an error because CUCS failed to object to Ames' counterclaims pursuant to Rule 404B, and because Ames owns property adjoining CUCS's property. In Bernstein versus Sovereign 2009, this department held that the purpose of Rule 404 is to permit a party to remove for dismissal based on the grounds set forth under Rule 3211. In Security Pacific versus Evans 2006, this department held that the failure to raise the defense of lack of standing in either a motion to dismiss or in an answer results in a waiver of such defense pursuant to Rule 3211. Therefore, because CUCS failed to raise the defense
Mr.
of lack
Ames,
of standing,
this is Justice Moulton. I'm sorry to interrupt you. Let's assume you have standing. How do you get around the argument that, and what the court found, which is that you made too many successive summary judgment motions? You know, one usually must bundle all of one's arguments into a single summary judgment motion. Do you understand my question?
I don't see what one has to do with the other. And
well, I'm saying I'm allowing that you have standing. In other words, we can put that aside for a moment. I'm asking you the separate question.
Oh, I'm not asking for summary judgment in here. I've reduced. I'm only requesting that the court find that I have standing and remand the issue back to the court. I'm not asking the court to go beyond standing and to go to the issue of summary judgment.
So you just, this is Judge Gish, just so I can understand this procedurally. So your contention is that if we agree with you that standing was waived, then what needs to be done in this case is that the counterclaims you raised need to be adjudicated on the merits?
Yes.
Okay, I think we understand your argument.
Okay, and just to add a little bit more, in the Court of Appeals in Sunbright versus the Board of Zoning, the Court of Appeals said that an adjoining landowner is presumed to be affected by a change on the neighboring property and therefore technically has standing to maintain an action for a zoning violation. So whether it's procedural or not, as an adjoining landowner, I have standing. Moving on to the next appeal. The trial court's order, which granted CUCS an access license to install overhead protections, was made in error because real property law section 881 required CUCS to state in their petition and affidavits that such access was necessary to make their improvements. No such statements were ever made by CUCS simply because such access was not necessary. Additionally, the order granted relief not requested in CUCS's petition. The order was also in error because, first, the building code has no specific requirements for overhead
Mr. Ames, I need a clarification. You're saying that no access was required on your property in order to construct the sidewalk shed? Construct the shed, excuse me.
I'm sorry, my phone was ringing. Could you just repeat that?
Yes. You're saying that no access was required by CUCS in order to construct the shed?
That's right. For the relief that was granted in this order, that relief was for protection of my property, not because they needed it to put their building.
Wasn't it also for protection of any passerby?
No, because, and if you let me go forward, I'll get to that.
No, just answer my question, please.
There are no passerbys. It's not public property, and it's not publicly available to anybody. It's all fenced off and locked up.
Okay, you have 30 more seconds, Mr. Ames, on your direct argument.
The order was also in error because the building code has no specific requirements for overhead protections, and the building code only required CUCS to protect Ames' property if Ames afforded CUCS access to his property. Because such access was denied, CUCS had no legal requirement to provide any protections. There are two DOB hearing division appeals to support this argument. In New York City versus Rinaldi 2017, the hearing division found that there is no building code requirement for overhead protection, and furthermore, a search of the building code finds no requirements for overhead protections. In the appeal of DOB versus Micah 2020, the hearing division found that a respondent such as CUCS has no obligation under the building code to protect an adjoining property when access is denied.
Thank you. All right, let's hear from your adversary. Mr. Slowick?
I'm sorry, Your Honor, I was muted. Can you hear me now?
We can.
Okay, thank you, Your Honor. May it please the court. This application by the appellant today is counting previous motion practice at the lower court and his previous appeal, which was denied on May 7th, 2020. This is the 10th time we are relitigating these matters, which have been conclusively decided over and over again against Mr. Ames. All of the arguments that he's raising now have been refuted multiple times in the lower court, which went as far as to forbid Mr. Ames from further filings. And in a motion that was decided after this appeal was perfected, it's motion sequence number 9 in the lower court document, to, motion sequence number 8, to sanction him $5,000 for repeated and abusive filings. This is inequitable. It is abusive. In the lower court's December 9th, 2019 order, which is discussed in our brief at page 38, denying his motions number 5 and number 6 for partial summary judgment to the extent that it can be gleaned, because the court is undoubtedly aware in making their way through Mr. Ames's filings that it is often unclear exactly what it is he's asking for. Judge Crane wrote that that these prayers for relief were being denied for the 5th and 6th time, and said further motions, if baseless, will result in sanctions, and there shall be no further motion practice without prior notice to the court. I'm asking the court does have the sua sponte power under 130-1.1 to enjoin further filings and to sanction Mr. Ames for these repeated and abusive filings that often make no sense. Consider, just for an example, Mr. Ames' contention that he would be subject to charges of committing a misdemeanor if the CUCS building was built contrary to the zoning resolution. These are untenable and claims lacking in any substance. With regard to what Mr. Ames alleges today, the Sunbright case alleges that standing requires an injury. Mr. Ames has never articulated an injury. If anything, the completion of this building, which is now complete and ready for occupancy, rendering this whole thing moot, excuse me. Here are the injuries that Mr. Ames claimed he sustained on pages 18 and 19 of our brief. Some tiles on his roof were misplaced. Stray cable wires on his roof were found. He missed a softball game. He had to cancel a lunch date, and he had trouble sleeping, and his social life was impacted. These are all injuries purportedly stemming from CUCS's construction activity. It is a
Counsel, if I may, the building on Mr. Ames' property is occupied?
No, the building that CUCS was building that resulted in the petition, the 881 petition, was to access Mr. Ames' property to put protection measures on it.
Oh, so, I know. I was just asking because you said that he couldn't, the allegation was that he couldn't sleep.
Yeah, and he doesn't even live in the building. The building on his property is a one-story uninhabited shack that doesn't even have utilities. It's unoccupied save for the occasional trespasser or vagrant. No, he was saying that the effort to oppose this construction upset him so much that he couldn't sleep. This is what we're talking about in terms of damages. This is completely baseless and meritless. And again, this is the 10th time he's relitigating it. Eight motion sequence numbers at the lower court, 2 appeals already heard and decided by this court. Then we're here again today. He has perfected 2 more appeals, and he has since also been found in violation of the court's order to refrain from further filings, and he's been sanctioned by the lower court. So I can, and with regard to his contention here that that access wasn't necessary, the building code required us to protect his property, which is why we brought the 881 petition for a temporary license to do just that. And that is what we did.
Okay, thank you. Your time is up. All right, Mr. Ames, you have 2 minutes.
Yes, thank you. First off, this is not really getting, the only issue the only issue on one of the appeals is whether I have standing, and that's never been litigated at the appellate court. And the fact that I do have standing, because Sunbright does not require damages, I didn't plead damages, and all the damages that Mr. Slowick claims I said, those are not damages from the construction of their from their zoning violations. He's just making all this stuff up. It is a misdemeanor to allow someone to construct a building which violates the zoning resolution, and that is in my papers.
Well, how would you be responsible for that?
If I aid in the construction of an illegal building by giving them access to my property.
How could you? You're not giving them access. It's a court order that gave them access. You certainly did not give them access.
Oh, fine. We don't have to go down there. But the point is,
yes, we have to. We have to.
Why?
Because you said you'd be responsible for a misdemeanor in aiding them to violate the zoning resolution.
That was only.
And I'm trying, quite frankly, Mr. Ames, to make sense of that.
The argument there is that the court should have decided whether or not they were violating the zoning resolution before she gave them access to my property. It's an affirmative defense. I don't even need standing for an affirmative defense. If they want access to my property to put up an illegal building, and I say they're putting up an illegal building, that should have been adjudicated initially. And the reason why there's so many motions in the case is because I never had my time in court for my affirmative defenses and for my counterclaims. That should have been done from day one. And the court didn't rule on my summary judgment motions for many, many months, and all these motions got intertwined. And the fact that this ruling was the first time that the judge said I didn't have standing meant that she never looked at the merits of any motion for summary judgments on the merits.
All right, I'm going to ask you to wrap it up because your rebuttal time has passed. So finish your final thought, and we're concluded.
Well, I have standing because Sunbright doesn't require damages. I'm a joining owner. Procedurally, they waived it. And as far as access to the property, they didn't ask for that access in their petition. Okay, they were granted relief that wasn't in the petition, and the building code doesn't require it, and they didn't supply affidavits that it was necessary to put their building up. So it was
okay. Thank you. We have your briefs. And I think we understand your arguments.
Thank you, Your Honor.
Northern Manhattan against Civil Court.
Your Honors, may it please the court, for the petitioner appellant, Northern Manhattan Equities LLC, Rosenblum Bianco, and my name is Tracy Beauchart. Good afternoon to everyone. This case is unique in that we're actually challenging the decision of two lower courts below. And we believe that they both acted in error, and that because the court directly below, the Supreme Court, denied my client's petition for Article 78 mandamus review on the lower court's refusal to grant a default judgment, the Supreme Court erred. And the Supreme Court erred because the—
So can I ask you a question? And it's a procedural question, but I think it needs to be addressed. Couldn't you, when the civil court denied your application for a default judgment, couldn't you go right to the appellate term with a 5704 application?
No, Your Honor, we thought about the various pathways to address the decision, and we don't see 5704B, or we didn't see it, and we still don't see 5704B as a remedy. 5704B presumably would allow us, because we're a civil court case, to go to the appellate term.
Right.
But because the route to that would be via, the right to such relief is by ex parte application, denial of ex parte.
Well, isn't a denial of a request for a default judgment, isn't that an ex parte application that's been denied?
No, it's actually.
What else would you call it?
It's a procedural operation. This has been addressed.
It could be both.
I guess to a certain extent, it could be both, depending on the facts. Judge, I won't disagree with you. But in regards to these procedures, the Court of Appeals has already determined that the RPAPL's requirement that the court shall issue a default judgment upon failure of the respondent to answer. It's been
that goes to the merits. That's a different issue.
Oh no, but
I'm really wondering if you brought the right procedural vehicle to bring it before the court. But you believe you have, so if you want to argue the merits, you can use your time to do that.
May I just ask you, follow up on that? This was an order that was denied without notice to the other side, correct?
Correct. There was no.
And isn't that exactly what I'm looking at CPLR 5704 right now? And those are the exact words. Without notice to the adverse party, you can go up to the first department. You can go up to the appellate term. And that's exactly what happened here. So I don't know how. So why are you in the appellate division from a civil court question without going through the appellate term? That is, to me, that seems like you are attempting to evade the correct form of appellate review.
Your Honor, we believe it's distinguishable because it's not the and again, Judge Gish referenced that I was headed towards the merits to discuss what the court has to do, but they are inexplicably intertwined in this matter because
I actually that's not why I was letting you go to the merits.
Okay. Well,
Judge, I know that we have a threshold procedural issue here, and we'll decide it one way or the other. We may never reach the merits if we disagree with you. They're not intertwined at all.
Okay, Judge, I do understand that the threshold issue is the most important issue, and that's why I'm talking on it first. But I think that they are intertwined, and I think because the language of the RPAPL says that the civil court shall issue, it removes this from the aspect of being an ex parte application. We're simply asking for a ministerial task to occur. And that's
counsel. Ex parte doesn't mean, ex parte means without notice. That's it. It doesn't mean that it's a may or a shall. It means without notice. And that's what happened here. You put an order in front of a judge or a proposed order without notice to the other side. It has nothing to do with whether or not the judge was required to sign it. And in fact, the only issue in that regard is then you should have gone directly up to the appellate term and said to the appellate term, this is a required order.
Well, Judge, I understand the point, and it is something that we considered when we received this, but we don't see the act of the civil court as even resulting in an order. The document.
Counsel, but isn't the paper entitled decision/order?
The caption on top is decision order, but everything is struck with an X across it.
Yeah, but forget about the but, because there's a writing at the bottom, right?
Yes, correct.
So the court has the ability, the authority certainly, to cross out part of a form order and substitute an original writing, right?
Yes, they can. But in this case, Judge, Judge Headley's language is declined. It's not.
You know what? This is Judge Gish again, because we have a little bit of familiarity with 5704. Certainly, Judge Gonzalez does up at the appellate term and at the appellate division, because there's a separate provision. And I tell you what you're saying doesn't jive with our experience with a 5704 motion, or really it's a proceeding that comes up to us frequently when a court declines a part or in a whole, or declines to sign an order to show cause. It comes up to us on a 5704, and we make a determination, yes, it should have been signed, or it shouldn't have been signed, or we decline it. So I just don't know why you couldn't get your relief there.
Well, Judge, this distinguishing aspect is 5704Bs involve discretionary acts. And because the statute outlines specifically that the court shall, it removes the discretion aspect from it. And that's really identical to what the Court of Appeals.
Where does that say that in 5704, counsel? I don't see that in the statute. So tell me where it says it. And number two, as I recall, when I sat in civil court and we had to sign ex parte warrants of eviction, if the judge declined to sign them, those went up to the appellate term. That was exactly what happened. So I don't know how this is any different from anything else that has been happening for years and years and years in other contexts.
Well, Judge, again, we believe, and I know we've gone through this, that the Court of Appeals has said specifically when there are ministerial tasks that are not performed, the course is Article 78, not discretionary.
Counsel, if it's only ministerial, if you don't have to have any, if I look at you and you didn't serve and you didn't serve the papers, but you want an order, and the court, and if you've checked off all your things to get the order, then I'm required to sign it. But if I find you haven't served it or you haven't served it properly, that's not a ministerial task, deciding whether or not you've complied with the underlying requirements to get the ex parte order, right?
Judge, I don't disagree, but.
So again, I'm still not figuring out why you think this isn't going to the appellate term.
Because when we get past the issue, when we look at RPAPL 732.3, what it says, and you referred to actually the proper analysis, which is whether or not the papers were served. That's where the analysis ends. If the petition and the notice of petition were properly served, and I'm reading directly from the statute to you, it's in my papers, and I'm sure you're all familiar with it, but if the respondent fails to answer within 10 days from the date of service, as shown by the affidavit or certificate of service of the notice of petition or petition, the judge shall render judgment in favor of the petitioner. We have that element. What the respondent did was the respondent went further and looked at other documents, and that's going beyond the ministerial aspect of it. It's becoming.
Counsel, I have to tell you that I'm listening to you, and no matter how you twist it, this is kind of a routine bread and butter issue that you could have appealed to the appellate term.
Judge, again, I think that the Court of Appeals has already guided us that we have to go this route. And I don't, again, I think that the discretion versus shall aspect of what we asked the lower court to do is what divides us or distinguishes us from going to 5704B.
All right, let's hear from Ms. Jang.
Good afternoon, Your Honors. I'm Mindy Jang on behalf of the Civil Court of the City of New York and Judge Canatero. And I think Your Honors have stated it exactly correct that petitioners could have gone directly to appellate term, or they could have filed a motion to vacate Judge Headley's ex parte order, and then
it would have had to been an ex parte order, though, an ex parte motion. Already had a default.
Right.
So that doesn't make a total amount of procedural sense. That's why we have 5704.
Right. And so they have that option. I think they saw that what the procedure was in Brusco v. Braun, but that was a very different case where the civil court judge was importing a non-statutory procedural hurdle, and that was why that case was appropriate for an Article 78.
Well, right. I mean, quite frankly, if we agree with you procedurally. It doesn't make the issue go away. We're just kicking the issue down the road a little bit. Going to have to confront the issue of whether this provision of the RPAPL applies to commercial tenancies, right?
Sure, yes, and I'm happy to address that issue. I think the entire Article 7 under the RPAPL talks about summary eviction proceedings, and it doesn't make a in Section 711 of the RPAPL, it doesn't distinguish between commercial tenancies or residential tenancies. And if a commercial landlord wishes to
let me ask you a simple question. Did 711-2 ever, did you just fall? I'm sorry. Did 711-2 of the RPAPL prior to the enactment of the HSTPA in 2019 ever distinguish between commercial and residential tenancies, or were the notice provisions the same with respect to non-payment proceedings?
It was the same, and petitioner even admits that they were okay with complying with RPAPL 711-2 when the notice requirement wasn't so onerous, in their opinion. But now they feel like since it's a 14-day notice requirement, they think now it's that they can't abide by that situation or that rule, and they think now that commercial tenancies should be excluded. But if you really take them out of the statute, you're operating in this, free-for-all situation where they're saying that they will just, determine via contracts how evictions will proceed. But this, the summary eviction proceedings are a statutory beast, and you have to consult the statute.
Counsel, this is Judge Scarpula. So I guess basically what you're saying to us is even if we consider the mandamus, there isn't a clear right of relief here. That it's a subject up to considerable debate, and we shouldn't force anybody to issue an order without having fleshed out that issue.
Right. Well, I think that Judge Headley made the correct decision.
I'm talking about Judge Angoran now, right?
Oh,
We're in the Article 78, and the petitioner is asking us, make him sign it. And you're saying to us that there is a reasonable interpretation of that underlying statute that Judge Headley got correct. And therefore, mandamus wouldn't lie anyway.
Right.
Okay.
Right.
Got it.
Your time is up, so let's hear from your adversary on rebuttal.
Well, Judge, I think it's very important to note that in regards to relationships between commercial parties, the Court of Appeals has spoken and given broad discretion to the parties to negotiate anything and everything, and rarely is something taken out of the purview of the parties to agree to or to even waive.
Can I ask a question, though? But under your way of looking at this, that this is just ministerial, then how do you distinguish between commercial and residential tenancies? I mean, why would it be ministerial as to one and not as to the other?
Well, Judge, I'm not sure I understand the question.
Your gripe, as I understand it, is that 711-2 doesn't apply to commercial tenancies, right?
Correct.
All right, but your argument as to why you're up here is that it's just ministerial, courts can't look at it. Well, if that's true, then why would you be able to look at it? It's the same statute. Why would you be able to look at that in the context of a residential tenancy? Well, Judge, how do you make that distinction?
I don't know that we have to, and I think that if I were before you on a similar circumstance in a residential case, I could probably make the same argument, because the analysis from 732, as I said before, is that all that has to be complied with is the procedural aspects of the service of the petition and notice of petition. And if that meets the muster of the court
Then
review.
everything else is irrelevant. Okay, I understand your argument. All right, thank you both.
I thank you very much.
Okay, Favaloro versus Port Authority.
Good afternoon. My name is Adam Kipnis. I represent the Port Authority. And one of the questions that we raised in our brief is whether the plaintiff's incident, that being stepping on a piece of plywood and falling into a hole at the World Trade Center site Tower 2, constitutes either a gravity-related risk or was part of usual and ordinary dangers of a construction site. And it's our position, as we set forth in our brief, that the plaintiff's incident here does constitute a incident involving a usual and ordinary construction site danger as opposed to a gravity-related risk. We cited to a number of cases in our brief which stand for the broad proposition that a 240 labor law violation can only be found to the extent that there is a significant differential in height between the elevation level of the required work and a lowered level. What we have here is not a significant elevation between the work that Mr. Favaloro was doing at the time of the incident and a lower level. We cited to a number of cases in our appellate brief with respect to that proposition. Specifically, we cited to Figueredo, Alonzo, Carpaccio. Each of these cases essentially stand for the broad proposition that there needs to be a height differential between the level where the work is being performed and a lower level. We don't have that here. And so for the reasons that we put in our brief, as well as these reasons, it's our position that the court below improvidently granted the plaintiff's motion for partial summary judgment on the 240 claim. There is a separate issue that we also raised.
So your argument, counsel, is that the fact that the co-worker said the hole was about 3 to 4 feet deep, and the plaintiff said that the hole was about 5 to 10 feet deep, that neither of those measures are dispositive because that's not a hole deep enough?
Well, there's been different testimony and evidence in this case.
Sorry. Or are you saying that falling down from the ground into a hole doesn't qualify? You talking about depth, or are you talking about the fact that you're not speaking? I mean, this isn't a pit. This is one of the pits at the World Trade Center, right? So it's a pit and it's a hole, and the man goes through a hole because there's plywood and it's black down there because it's nighttime and he doesn't have proper lighting according to his complaint.
I think in response, pardon me.
Is it the measurement, or is it the fact that it's at below ground level going further down below?
I think it's a combination of those two factors, and I'll explain why. There's no per se rule, so to speak, with respect to the depth of from one working level to another working level. The case law is generally in accord that there has to be some type of height differential. But in response to your question, there's been different testimony and evidence in this case as to the size of the hole. When the plaintiff originally testified in this case, he couldn't specifically identify the depth of the hole. He later corrected his testimony at the request of Judge Hagler with respect to the pending motions for summary judgment, identifying the depth of the hole to be about 2.5 feet. There's other evidence in this case. There's documents that have been produced in this case specifically by Halmar, which indicates that the depth of the holes varied in height, or depth rather, the smallest being 3 by 3 by 3. But the point being, there's been different evidence and different testimony in this case as to the depth of the hole. My point with respect to this gravity-related risk issue is the fact that, number one, as you pointed out, this is a hole in the ground, and number two, that because there is no per se rule and because there is no significant height differential, it doesn't constitute a gravity-related risk, and instead constitutes a usual and customary construction site type of danger. The other point that we mentioned in our brief concerns the trial court's decision with regard to the 241-6 provision, specifically the industrial code.
I'm sorry, I want to get back to this other concept that the hole in the ground doesn't qualify. Does it matter that there was planking down in this pit?
I mean, yes.
I mean, doesn't that make it more like, you know, scaffolding and then there's a hole and then he falls down? I'm having a hard time with you seeing this as not a gravity-related, elevation-related accident. I'm not following the reasoning.
Well, I think the protective, the piece of plywood would constitute a protective covering for sure. But the point.
And it was defective, apparently.
It was.
Everything indicated that it was rotted. Or worse.
Correct.
Right? And that's why he fell into the hole below.
Correct. The
Really?
point,
Not
broader. Sorry. The broader point that I'm trying to make and that we made in our brief is, again, because there is no per se rule as to the height differential, and because this was, broadly speaking, a hole, despite the fact that there's different evidence and different testimony in this case as concerns the height of the hole or depth of the hole, the deepest being 3 feet, the smallest being perhaps 2 feet to 2.5 feet. But my point is a 2.5 foot depth or a 3 foot depth in a hole in the ground does not constitute, in our view, a significant height differential
Even if
under 240.
No matter what. Okay. All right.
All right.
All right. We're going to hear from Mr. Theobald now.
Good afternoon, Your Honor. Chris Theobald of Shaw, Bahmany, Citron, and Spratt on behalf of defendants, respondents, appellants to World Trade, Turner, and Halmar. Just to turn back to the issue of the hole, just to clarify, nobody actually personally observed it. The only person in this case that you could, well, for whatever reason, nobody actually went down there and personally looked at the hole. Plaintiff's coworker, who ventured to guess as to the dimensions, only a few lines later in his deposition acknowledged that he didn't personally observe it. So we actually have no idea what the dimensions of the hole were. The critical piece of testimony that I think Mr. Kipnis omitted is that the plaintiff was very adamant at his deposition that it was too narrow for him to fall into. And I think that's the reason why this isn't the type of significant elevation-related risk that the statute contemplates, because in none of the cases cited by plaintiff did the court find that a partial fall.
So you're saying that a partial fall doesn't qualify? Because I thought that it did.
In the cases where a partial fall qualified under the statute, it was an opening between floors. In no case at a ground level is a partial fall into a hole a 240 case. There's been no. In fact, in other departments, that issue has been confronted.
So now it comes the question that I asked your adversary, but there was a planking here. It covered a hole. Yes. I mean, yes. You don't normally have pit accidents. I give you that. They're usually holes between floors as you're building up, but here you're building down. And so you put a planking down so you don't fall further into the foundational hole. Why wouldn't that qualify? Honestly, well, I conceptually, I'm having trouble with the distinctions being made here.
I think that there are two elements to what you're saying. The first is there a statutory risk under 240 present? And secondly, is there a safety device? I would agree with you that the plank was meant to be a safety device. It was fall protection on this record.
Defective, right?
Defective, correct. But that doesn't obviate the need for there to first be a physically significant elevation differential, and that simply wasn't present here because, as the plaintiff adamantly testified, he could not fall into this hole. It was too narrow. It was too narrow. So that's why I think this is not a 240 case. And I think that if we were to extend, I mean, the whole analysis turns out.
I don't agree with you. Someone's body doesn't have to fall through a hole in order for it to be a 240 sub 1 case. I was on a case last year where a guy fell into a trench of loose soil. So right. His fall was impeded a little bit. That case was Sunan.
Right, right. I read that case.
You may be familiar with that case, but his body couldn't go through all that soil. He went up to his thigh. And that was a 240 sub 1 case, and he won on summary judgment. So I think you're overstating what someone must show to make out a 240 sub 1 case.
Well, I think the difference here is that we have no idea as to the dimensions of the hole. We'd have to know that first.
I misunderstood. I thought you were saying that he had to be able to fall through the hole in order for it to be a 240 sub 1 case. So I'm sorry if I misstated what your position was.
Well, in all the cases that have dealt with holes, the plaintiffs have been able to fall through the holes, or if they didn't actually fall through the holes, the hole was between two levels. It was at an elevated work site. It would truly be unprecedented to extend liability to a case like this, and other departments have explicitly rejected that. So if we were to do that here, there would be an interdepartmental dispute.
So you're saying that if this department rules that a partial fall into a hole at the bottom of a pit at the World Trade Center site is going to cause a departmental distinction?
Not only
contradiction. Is that what you're saying?
Not only, I'd add the caveat that where it's impossible to fall fully into or through, because that's what the plaintiff here testified. He said it was way too narrow. I could not fit in it. Because there are cases where a plaintiff does partially fall into a hole, but he catches himself or something like that. The possibility of falling through exists.
Yeah,
that possibility is not.
This is Judge Scarpullo. What possible relevance does that have? That he's 200 pounds and he didn't go all the way through, as opposed to 90 pounds and did. What possible relevance as to statutory, or he's 5 foot instead of 6'3"? Right. That can't be right, because that would have to, then you'd have to decide, well, only a skinny guy could go through, or a 5 foot guy could go through to his neck, but a 6 foot guy couldn't. I don't understand how that could be the standard.
It goes to the significance of the elevation risk presented, and where you can't see the cases dealing with this, they liken the risk to falling off a drop off or a contiguous, where there's a serious risk of actually falling through something or off something. The risk is simply not analogous. It's not. You're saying
a fall of 3 feet isn't enough?
But he couldn't have fallen 3 feet by his own testimony.
Because of his weight, or because of the way he fell.
Whatever the case.
What I'm saying to you is, I can't imagine that would be the difference in the statutory liability or not.
Oh, I think it creates a categorically different kind of elevation risk that the statute wasn't intended to cover.
Because I'm shorter rather than taller, or heavier rather than thinner?
Well, whatever the case may be. I mean.
Okay. All right. Let's hear from the plaintiff.
Good afternoon, Your Honors, and thank you. May it please the court. The court below correctly ruled that Section 240 sub 1 was violated when Mr. Favaloro fell in the hole. I'm going to just quickly address some of the misstatements of facts that my adversaries just made, beginning with the fact that he couldn't possibly fall through the hole. He testified that he did fall into the hole all the way up to his hip. And he testified that the reason that he didn't fall all the way into the hole was because one leg fell in and the other leg was still outside of the hole. And his legs were in a Y situation when he fell into the hole. So that the left leg was outside of the hole and the right leg was inside the hole. And he fell all the way into the hip. So there's no question that he fell into the hole. And there's no question that the hole was large enough, and the record will show it because there's photographs that have been submitted to show the size of the hole that he could have fallen into. The reason he didn't was because the protective device that ended up failing, the planking that they put over the hole, prevented him from falling the entire way into the hole, his entire body. But that doesn't mean that his leg didn't go all the way down. There's a misconception as to there's no idea what the dimensions of the hole is. They forget that this is a footing that was excavated, and their own witness, Halmar's own witness, Leo Dragon, testified that this footing was at least 3 feet deep, or it could have been 6 feet deep, or it could have been as much as 12 feet deep. There were different holes for different footings that were created. So when we argued in the brief, we took the smallest hole possible, the 3 by 3 by 3. So it was at least 3 feet deep. But if you look at pictures, what the footing is shown there is much larger than a 3 foot by 3 foot footing. It's probably more than 6 foot deep that he didn't fall all the way into. So we do know the size, the dimensions of the hole. Mr. Favaloro testified to it. It was at night. He didn't have a measuring tape. He didn't take dimensions of the hole after he fell into it. He gave his best recollection. the independent eyewitness who worked there all the time and who would see the holes on a regular basis said the hole was about 3 feet deep. There was an investigator from Turner Construction that went in there. His name was Pat Donovan, and his testimony is cited. And Mr. Donovan said that in the report, which is at the record at 538, that the hole was perhaps 2 feet by 10 feet and at least 3 feet deep. So we know that the hole was at least 3 feet deep, and this court and other courts throughout the state have over and over found such a depth actionable. Now,
Counsel, can I ask you to address counsel's argument that if we affirm this, then we are going to create a division in the departments?
I mean, that's just untrue. All of the cases that we all seem to cite stand for the same proposition. For some reason, I think perhaps counsels didn't read through all the cases, because the cases such as O'Connor versus Lincoln, where a plywood cover shifted and the plaintiff did not fall all the way through, and this court found liability. We have the Carpio case, which I cite in my case. The plaintiff stepped into a 10 by 14-inch hole, causing only his leg to fall approximately 3 feet to his groin level. This court found liability in that case. We have the case of Campisi versus Epos Contracting. Once again, First Department. The plaintiff did not fall all the way through. The plaintiff stepped into a space between 2 floor joists, fell through up to his elbows, dangled between the first floor and the basement, and this court found liability. We have cases, obviously, that the plaintiff did fall all the way through, and those are cited in my case. And most recently, the Honorable Judge Moulton was involved in the Sununu case, which I also cited. Again, the justice already addressed the fact that the plaintiff sank into earth, and 240 liability in that case was granted. The one case that is cited by counsel for the appellants and defendants is the DeGidio case, which would tend to, I guess this is what they're hanging their hat on. It's a third department case. But in that case, the plaintiff clearly wasn't working at any sort of elevation. The plaintiff was standing on a permanent floor that had been raised 15 inches inside of a computer room, and his foot fell through the floor. There was no safety device implicated in that case, and there was no scaffold or anything that failed. So that case is completely inapplicable to the facts here. We have here a situation where they excavated footings. They covered the footings with some plywood, haphazardly threw down plywood to protect, I guess, to use as fall protection. And that's something that Halmar's own superintendent, Leo DeGrone, testified to. We placed that plywood there as fall protection. And those are the words he used, and they're cited in my brief. And that fall protection failed. This is a classic 240 case.
All right, thank you. All right, let's hear rebuttal. Let's start with Mr. Kipnis.
Thank you. With all due respect,
may I ask you a quick question? With respect to the illumination and the allegation that the illumination was inadequate, do you concede that point?
No, we don't. In fact, we raised it in our brief as to one of the bases that the court incorrectly decided the motions for summary judgment.
May I ask you then to reflect on Mr. Monforte's statement? He was Turner's site safety manager, that it was unsafe to work in the dark like that, and that Turner wouldn't work into that type of condition, working condition.
He did testify to that. I do acknowledge that. However, there's other people in this case who have testified differently. The plaintiff's supervisor, Matt Cicchetti, who Mr. Favaloro directly reported to, was deposed in this case. And he had testified during his deposition that he was in the Tower 2 footprint at night. And he had also testified that that there was sufficient lighting. Look, I'm not going to say that this was
Counsel, if I may, he went to the site at 6 in the morning, and he said that the lighting was adequate.
he actually testified not on this specific day, but on prior occasions before this particular incident that he was in the Tower 2 site at night. And he specifically said during his deposition that, in his opinion, the lighting was adequate. In addition to him, Leo Dragon, who we've been talking about here today, he was the project manager for Halmar, also testified during his deposition that he too went into the Tower 2 footprint at night, and he too said that it was adequately lit. So it's not just Mr. Monforte's deposition that has to be considered, it's these other individuals whose testimony has to be considered as well. And that it's by virtue of the conflicting deposition testimony, which is, I guess, the way that I would explain it, it's our position that at a minimum, the motions for summary judgment, our motion on the illumination issue, as well as the plaintiff's motion concerning the illumination issue, should have been denied just by virtue of the fact of there being an issue of material fact.
Right, thank you. Let's hear from Mr. Theobald. Mr. Theobald?
We can't hear you. Your mic's on.
Are you?
I'm sorry about that. Yep, unmuted now. You can hear me, right? Okay. On the issue of notice, with regard to the illumination issue under 241 sub 6, there's an issue of fact on that element as well, because plaintiff testified that he complained about the illumination, and his supervisor, Matthew Cicchetti, denied receiving such complaints, as did Port Authority safety specialist Pat Donovan. So that's another clear issue of fact that renders summary judgment inappropriate.
Was there affirmative testimony that there was adequate illumination?
Again, as Mr. Kitness just laid out, that's a disputed issue as well.
I know you're saying that, but I'm asking you now. Who disputed it, and where? And just if you could point me in the record, because quite frankly, I didn't see it. But if you could point me, I'll look at it again.
So Matthew Cicchetti disputed that. I'll have to pull up the record site for you. But not only that, but plaintiff said he was wearing a headlamp at the time, but he couldn't say how.
Counsel, that the headlamp was inadequate to light the general area. It was specific to the light provided was used to do the work relative to the pumps, right?
Well, he couldn't exactly say how expansively his headlamp illuminated the area.
So you're arguing that a headlamp is big enough and powerful enough, and the record supports what you're saying, powerful enough to light a whole area in pitch black, in a pitch black pit?
I'm saying that that's part and parcel of there being an issue of fact on the point, that being in addition to Cicchetti's testimony that the illumination was sufficient. But even if the illumination weren't sufficient, there's a clear issue of fact on the notice element, which I think makes summary judgment on this cause of action improper at this point.
Well, that would be a 241-6 claim. I'm not sure about notice, but okay. All right, let's hear from Mr. Chinigo.
Thank you, Your Honor. The independent eyewitness, Jesse Van Son, at the record 218, testified that it was dark down there, that the lighting was inadequate, and that he had complained. When asked who he complained to, he said it wasn't Matt Cicchetti, it was two of the other supervisors at Moore Trench that he complained to, Sammy Kosak and Danny Dimler. That's record at 218. You have Mr. Donovan talking about the fact that the area should have been lit and that it was dark. You have Mr. Dragon at record 321 admitting, yes, it was pretty dark. You have Mr. Monforte, who was shown the photographs, and he said, as Your Honor pointed out, yes, it's dark. I asked, based on your experience as a site safety manager, would it be safe to send workers to work in that dark portion of the photograph? And he answered, basically, no. No one would work in the dark like that. When I pointed out more trench workers were working in the dark like that, he said, not for us. I said, I didn't say that it was for you, but that would be unsafe, right? And he answered, that's true. We would never send our workers into that condition. That was his testimony. Donovan, the Port Authority's own person, at 5:38 in the accident report, he said, however, he did not realize it was only partially covering it because there is poor light down there, even with flashlights. That's Port Authority's own person who emailed this accident to his supervisors, reporting that it was dark down there. And the evidence is clear that it was dark down there. There is no evidence. There is no affirmative evidence whatsoever that there was any light down there, except for some light that came from the streets. That's not enough under the Industrial Code section.
Your time has run out. Thank you all.
Thank you, Your Honors.
Thank you.
Thank you.
Okay, our last case is Storino. All right, I'm going to start with Mr. Feinberg. I'm going to give you 8 minutes. Go ahead.
Thank you, Your Honor. I'm Ira Feinberg of Hogan Lovells, representing Appellate New York University. The issue in this case is whether it was rational for NYU to determine that the conduct of these students attending parties with other NYU students in the midst of the pandemic, where neither they nor anyone else was wearing masks or social distancing, threatened the health and safety of the entire NYU community and warrant imposition of disciplinary sanctions.
May I focus you in a little bit? The lower court basically agreed with you on most issues except one. She said that prior to the time that the students were that the students weren't given prior notification that the conduct in which they were engaging in would be subject to penalties. Is that true?
No, Your Honor, it's not true at all.
Could you address that? What kind of notice did they receive and when?
The trial court's fundamental error here was in focusing on NYU's communications to students over the summer of 2020 and disregarding the policies under which these students were actually found responsible for violating. They weren't charged with violating anything that NYU said over the summer. Instead, they were found responsible for violating two longstanding policies that broadly prohibited conduct by students that endangers the health, safety, or well-being of themselves, other people, or the general university community. And those policies, this is the standard code of student conduct that governs at NYU, make it explicit that when it comes to conduct that threatens health or safety of the university community, NYU can impose discipline for conduct outside the university conduct.
Wait a minute, Counsel, this is Judge Scarpula. You are saying that general policy that has nothing to do with COVID, has nothing to do with 10 or less people, has nothing to do with mask wearing, is specific enough to give the students notification that if they sat on their roofs with more than 10 people and without masks, that they were going to be suspended? That's what you're putting your hat on?
Your Honor, yes, we are saying that that policy is that, Your Honor, most universities have similar broad policies, and the courts have routinely upheld applications of those policies to student conduct. Let me give you a couple of examples, if I might.
Except, let me just say this to you. It is always illegal to do drugs, but until this pandemic, it was not, no one was required to wear a mask ever. There were no clear views about whether 10 people was enough or 20 people was enough. So I disagree with you to the extent that you are saying this specific conduct, which in any other time in the history of the world would mean nothing, the students would get notice from your general policy about this conduct.
Your Honor.
Do we agree that if it was 2018 and those kids under this policy were sitting on their roof having a cocktail, that we wouldn't be here today?
Of course, Your Honor.
Okay, so that I don't see how you can argue that general policy gave them the notice that they needed to have. I mean, I can see you sent emails over a period of time telling, being specific about this conduct. But the general don't do bad policy, which would never be connected to this behavior other than this pandemic, I don't see how you could argue that.
Well, we think that is in fact what the law requires. There's no requirement for such a specific notice requirement in the law. The courts are required to defer to NYU's interpretation of its policies. And that's what the courts has held. That's what this court held in a case called Lambert versus Fordham University, where the students were disciplined for an alcohol-related violation.
Counsel, let's assume for the sake of argument that we agree that that there was a new legal standard created that perhaps should not have been. Let's just say that for the moment. So are you saying that policies, for example, B1 and E1 are sufficient for this type of sanction to be meted out to the students? Are you saying to us, read B1 and B2, the bullying, threatening, and abusive behavior policy B1, the disorderly conduct policy E1, look at those, and also look at the communications that were issued starting in July of 2020 as a result of the pandemic? Do we have to read them together, or are you saying that that policy B1 and policy E1 are standalones sufficient to suspend the students?
Your Honor, I think they are sufficient, but I think you're making a really important point, and is that the communications that NYU sent to its students over the summer gave them all the notice that they really needed to have here as to this conduct, and that Judge Edmeade in the court below gave them an unduly narrow and unreasonable interpretation. For example, the July 30th communication, NYU, this is before any of the conduct at issue here, NYU sent an important communication to NYU students, that's what they called it, that was explicitly addressed to things that the students must do ahead of the beginning of the term, including quarantining for 2 weeks before getting it.
If you would just stop there for 1 second. So that communication on July 30th focused on, in my view, two things. One, the quarantine restrictions slash testing requirements, okay, and also a caution that there would be new safety and health rules for the coming academic year, and students who fail to adhere to the rules may face specifically formal disciplinary action. Okay, so we know that the information during the course of the pandemic changed as far as the mask requirement is concerned. So is that the beginning of the important communications, or is the July 30th communication the definitive one? Or alternatively, is it the August 14th communication that we need to focus on?
This is the beginning of the communications. There were a long series of them. And I want to point the court to the record at page 249, where the policy, this is the July 30th communication, says, this is a moment of challenge for us all. To have a successful semester, we must all strictly abide by the new COVID-19 health and safety protocols, wearing a mask, keeping social distance, hand washing, not coming to class if you feel sick, being tested, et cetera. Together, we help keep each other safe. Safety can't be imposed. Each of us has a hand in it and a responsibility to one another. There is nothing in that admonition which says this doesn't apply before the term starts. And there's nothing in that admonition that says that it doesn't apply when you're off campus. And Judge Edmeade was wrong to interpret those things so narrowly. But let me focus on the August 14th communication, because there NYU sent to students required them to watch a video and to sign something that said that they had watched the video and would agree to be bound by it. And I'd like to point to you page 255 of the record, because on page 255, it says, and this is a screenshot from that video, the NYU rules of gatherings should be applied when you're off campus as well. Bars and parties should be avoided because of their well-documented role in spreading the coronavirus. And petitioners say—
Mr. Feinberg, let me stop you with respect to that particular communication. Is there any issue raised by the effective date of that communication? Because there's some indication that the students were told they had to read it by August 24th.
That is true, Your Honor, but it is important to note that petitioner Santo Nocito in particular read it that day. He certified that morning that he had watched this video and saw that admonition I just read to you. And then he went to this party that very night. And the photograph that's in the record, which is at page 344, I think it is, either there or 502. The photo that was taken that very night after he had read that ammunition and certified that he had read it. It is inconceivable to me how the trial court could have given him a pass for that conduct.
I want to—
How about the students who didn't read it before they went to the party? And prior to that, there had been nothing concrete other than your statement that a general don't do bad should be applied to this situation, which in two years ago, and let me just go off on a side, it's always wrong to drink too much. It's not like in 2018, it wasn't wrong to drink too much. In 2020, it was. This is a different situation. This is a situation where conduct that would normally never involve anyone being sanctioned is now for the first time being sanctionable. So I don't know how you can compare it to don't drink 37 drinks off campus and not expect to get that. It's just not comparable. And my question to you is, should we hold everyone responsible for knowing about this policy on the 14th if you told them they didn't have to read it, they didn't have to watch the video and certify till the 24th?
The answer is yes. These students should still were properly sanctioned. The July 30th communication that I read earlier gave them ample notice of what conduct was expected of them. And on top of that, the petitioners make a big point of how they complied with all city and state guidelines, and that's simply not true. The city and state guidelines, for example, and petitioners make this point, they allowed gatherings of up to 50 people. Sure they do, but gatherings of 50 people with masks and social distancing. They don't allow people to attend a party, especially one that was indoors. And if you look at the record here, one of those photographs,
when you
the
say
party
that,
was indoors. I'm sorry, Ron.
I'm sorry, where in the record is it of the restrictions that existed in the city at that time in terms of what the congregation could be? In other words, you're talking about the city restrictions. Where are they at that time in the record? Just point me to it. I didn't see it.
The petitioners have brought this up. It wasn't, it is somewhere in the record. I don't have it at my fingertips, Your Honor. I could submit a letter after argument.
Your understanding is that at that time, the restriction of the city was 50 people, provided there was appropriate social distancing and masking?
I think that's a state requirement, not a city. And I think that the governor's executive orders, we were in phase 4 of the reopening from the shutdown, and the rules at the time were allowed up to 50 people to gather. But there was nothing in that said you didn't have to pay any attention to social distancing and masking. And the idea of 50 people gathering.
Well, there's a difference between there was nothing and there was something in the directive that said you had abide by it. You know, I think, I mean, one of the things that I think Judge Edmead grappled with, and that we're trying to grapple with too, is that there was no directive out there from the government agency, at least we could tell. If I'm wrong, I'd happy to know about it, because I think it changes the calculus that would have prohibited this behavior. And while certainly, I personally believe that the university had the right to restrict the behavior. The question was really, did the students know what behavior they had to conform to? And I think that's really at the gist of Judge Edmead's decision. You know, leaving aside the issue of whether, you know, she had a different standard or not. You know, just factually, did they know? Could they have known that being with 12 people on the rooftop without masks would have subjected them to a determination by the school that they were violating health codes?
Sorry, Your Honor. They certainly should have known and were on notice. For example, the governor's executive orders, and I'm sorry, I don't have the citation onto the record in my fingertips, but I can get it for you later. But they say bars and parties should be avoided, and the
well, I don't know. I'm not really, I would have to look at that too, counsel. This is Judge Scarpula, because as I recall in the summer, everyone was outside. And as long as if you were outside and there was free circulation, there wasn't a requirement that you wore a mask. If you were outside within 6 feet of someone, I don't recall exactly what it was, but I agree that the university could make a different requirement.
Yes.
But the question is, where is that different requirement set forth? And when did you give the students notice of it? Because certainly saying comply with state and local, I mean, we'd have to see what they were at that time. If you're saying comply with state and local rules, I think rooftop parties might not have violated the rules. So if you're saying, I think we all agree that you can make a different rule, but you have to tell the students it, and they have to know that doing it is violation. And since it wasn't a violation last year, I think you have to be more specific than do right. Don't be a bad person.
Your Honor, in terms of, I mean, first of all, I don't think these students were in compliance with city and state rules. And if the court would give me an opportunity to submit something in a letter after argument to try to detail that in the record, I'd be happy to. But in terms of the specific things that NYU said, I think the two things that I have pointed to already on July 30th and August 14th are the key ones that from our perspective gave students sufficient advance notice that the conduct they had to comply with.
Okay, let's hear from Ms. Edler.
Good afternoon, Your Honors, and may it please the court. My name is Karen Edler from the firm of Price, Meese, Shulman, and Darminio, and I am here today on behalf of petitioner respondent appellants, who I'm going to refer to for ease of reference as petitioners, and I'll refer to respondent appellant respondent as NYU. Petitioners respectfully request the court affirm Judge Edmead's decision finding NYU's disciplinary actions against petitioners that were arbitrary, capricious, and constitute an abuse of NYU.
So let me ask you a question, because we are really honing down on a limited category of issues. Is there a place in the record that indicates what the state directive was at the time that these parties were held?
Yes, Your Honor.
And where is that?
There are two. If you go to the record at 131, at the time Governor Cuomo declared New York City was in phase 4 as of July 20, 2020. Phase 4 of the New York forward reopening plan permits social gatherings of up to 50 people. Additionally, at 151 in the record, on February 15th or April 15th, New York State Governor Cuomo issued Executive Order 202.17, which provided.
Run that by me again.
So on April 15,
Yeah.
Governor Cuomo issued an Executive Order 202.17. This is the record at 151, paragraph 122. And it provided that effective at 8 p.m. on Friday, April 17, 2020, any individual over the age of 2 and able to medically tolerate a face covering shall be required to cover their nose and mouth with a mask or a face covering when in a public place, which is the key to this order, and unable to maintain or when not maintaining social distance. All of New York State's executive orders with regard to masks and social distancing applied in public places, which is also true. And which is being asked, the students involved were not in public. They were in their private residence or on the rooftop that was part of their private residence.
Counsel, you don't disagree, Counsel, this is Judge Scarpula. You don't disagree that NYU could make a more restrictive policy than that. It doesn't have to follow what the governor and them. I mean, the NYU could make a more, and I think what the NYU is saying, we did make a more restrictive policy because we think that students are different from the general public, right?
Right, and Your Honor, I would agree that they can, and in fact, they did on September 3rd, 2020. But these incidents that my clients were subject to discipline for occurred on August 12th, August 14th, and August 22nd, before the commencement of NYU's term.
So, Counsel, I want to put everything in context, if I may, and hear what you have to say. So we know about the general policies that affect student conduct and say you cannot act in a way that's deleterious to the overall campus health. And we understand that COVID, unfortunately, travels with you, irrespective of whether you're in a public place or in a private place. It follows you because it's part of you wherever you go. Okay, so if given the fact that you have an email on July 30th, 2020, that says these are the quarantine procedures, these are the early arrival procedures, there are going to be ongoing rules set forth, and if you don't follow them, you may be subject to disciplinary action. At the point where in August 2014, the email is issued saying your action required community standards in the context of COVID-19, and then the video contains the information. Do you think that the fact that the viewing of the video, in addition to the reading of the email and the completion of the acknowledgement saying that, yes, I've seen the email, yes, I've watched the video, and that had to be returned by, what was it, September? Sorry.
It was initially
by August 24th. You think that means that the students, by virtue of not watching the email, I'm talking about the two that didn't watch the email, you think that lets them off the hook?
Yes. First of all, the video is for the policy on the return. Everything that NYU sent over the course of the summer was about reopening. NYU was closed. NYU was coming back after being gone probably since mid-March, and was coming back and was preparing the students.
So counsel, but the video, the warning in the video was that the rules of gathering should be applied when you're off campus as well. Bars and parties should be avoided because of their well-documented role in spreading the coronavirus, and you may face disciplinary action accordingly. If you violate these.
I apologize for interrupting, but that is for when the term commences. In other words,
What makes you say that, counsel? What makes you say that's when the term commences if that language isn't in there?
Two things. First of all, they sent it out on August 14th. The initial date for the students to review the video and return it to NYU was August 24th. That date was extended twice to August 26th and August 28th. NYU clearly, if they wanted that video to apply on August 14th, they would have required all of the students to do it then. They would have highlighted that this was applying to the summer break. But that wasn't NYU's means. Mr. Jolly, in his affidavit, talked about the testing. So NYU created testing for when the students returned. Everyone was coming from different places, doing different things with, frankly, different rules for COVID in place in different states, and it's NYU, so we're also talking about different countries. NYU decided that its bellwether would be testing. All of the students who were going to come back in person who wanted to step foot on NYU's campus had to be tested. And they couldn't go on to NYU's campus or attend NYU's in-person classes until they had received a negative test. That is how NYU went to deal with the vagaries of whatever went on from March.
So this is Judge Gish. You believe that all they did was require testing and that was it? That there was no other policy about safety?
Not prior to the commencement of the term. The policies be pre-commencement of the term.
What about there is at least some that's indisputable about quarantining, and that was before this, had to be before the semester began.
Right, and that's what
classes without the required quarantining. So it wasn't just testing when you came back.
No, and I didn't mean it to mean just testing, but NYU's.
Just tell me, what date did the semester start?
September 2nd. So, Your Honor,
so you think that notification on the 14th, that it meant like you party your brains out until September 2nd, but come September 2nd, it's all over, kids. Yeah? Really?
Because what they're talking about is that upon return, certain categories of students had to quarantine. Not all students had to quarantine. The tri-state students were relieved of the obligation to quarantine because the tri-state was trying to function as one entity at the time.
Yeah, but the 14th video also talked about being in congregant settings, parties and bars, and you mean to tell me that they only meant that to start on the 2nd because that's when the danger for the university would really ramp up. Before that, there was no risk to the university for behavior like that?
If the university...
I'm having trouble following it, that's all.
Okay. Well, if the university is testing every student upon return and quarantining students who they feel are at a higher level of risk and testing before and after quarantine, the university was effectively assuring itself that they were bringing back a student body who didn't have COVID.
Well, maybe that would have been your determination, and maybe if you were in charge of the policy, you could have done that. But just as equally, certainly NYU could, and the question is, did they decide that for the weeks preceding you actually coming to the class, we need to put in some insurance measures to make sure you're not bringing disease into the congregant population, whether it's on or off the campus. I'm not sure. I see your view of what their policy is as so clearly as you see it. I don't see it at all.
Well, Your Honor,
I see it as something emerging as it was for everybody as they were trying to figure this out, as we're still trying to figure this out.
Right, and Your Honor, they did put together a policy that went out on August 5th. That's their COVID pandemic policy, which by its title was about the requirements related to access to NYU's buildings and campus grounds. That's the NYU policy that governed face coverings and physical distancing at all times while in NYU's buildings and on NYU's campus grounds. Had NYU—
So this is Judge Scarpula, though, do you not agree? In that video, on August 14th, NYU said to the students, you may not, if we find you in off-campus parties without having face masks on, you are going to be disciplined. Because look, that was true of most universities at that time. And I would find it difficult if you told me that that's not what August 14th, the video and the memo said. And NYU can do whatever it wants. It's a private university. It gets to make whatever rules it wants. So the question has to say to you is, assume that we think that is true. When do you think that notice to the students became effective?
As of the date, the final date upon which the students had to watch and submit it, which
was
ultimately was August 28th. The original date was August 24th. Even that date puts us after the conduct that these students were being disciplined. In fact, the original charge went out on August 23rd, prior to when they had to watch the video sign and return it. But the date had already been extended. My understanding was to the 26th and then to the 28th. NYU was keying everything off of everybody being back on campus right around that time and wanting to make sure that once they're all back, they're all abiding by its set.
Counsel, so here's my question. And it's a question that for me is an exercise of logic, perhaps. If the quarantine requirements are relative to, if you're talking about a 14-day if you're requiring the out-of-state students to quarantine for 14 days prior to class, and you're requiring the students who are tri-state to test at least 14 days prior to class, and you say September 2nd was the start of class. Okay, so you have to do the math for me. What's September 2nd minus 14 days?
I will give it to you in just 1 second.
Because I can't do it. I can do it on
a calendar. How's that, Your Honor?
Yeah, I can't do it.
It would be August 19th, Your Honor.
Okay, so doesn't the August 14th email have to be taken within that context, that it is part of a continuum of requirements, of perhaps escalating requirements, as we all experienced, escalating requirements that safeguard the health of the campus to avoid super spreader events?
And there's two factors there. One, the university decided that video only had to be watched and returned initially by August 24th. You have the students involved in this action were not on campus residents, and they had lease departments beginning August 1st, I think, across the board. And they had come back during their summer break to enjoy their summer break in Manhattan. These requirements that were put in place, there were kids who had to quarantine, who came back the 8th and the 19th, who were going to live on campus, who came from outside the tri-state. They came back. They were there on campus for 2 weeks. Now, even those students, to my knowledge, there was no different date that those students had to watch the video. Why? Because they were quarantined in their dorm. If they left their dorm, they were going to be suspended. So
yeah, so quarantine students could not congregate with 12 or 14 other students.
No, NYU put in restrictive requirements for the quarantine students. They weren't allowed to leave the quarantine. There were 2 weeks they had to stay within their dorms. I don't know every rule off the top of my head, but it was fairly restrictive, and NYU was feeding them and sending food to the dorms. So effectively, I don't think NYU was worried about those students going off and partying, shall we say, because it put in place quarantine rules for those students. The students that we're dealing with were not subject to those rules. They were off campus and they had to submit one negative test prior to stepping foot on campus. They were all actually going to watch their classes online. They were track students, but there was no sports. So there was no track.
So counsel, I don't think that the online nature of classes or not is dispositive here. I really don't, because the issue is the overall health of the university, faculty, students, workers, and so on. You know this, and you also know
that, Your Honor. But the point was, the university didn't require them to take to be tested and be negative, because they were going to be all virtual. So anyone who was virtual wasn't even required for the negative test. My clients took the test because they were living nearby and they might step foot on campus to go to a bookstore or to do something in conjunction with an activity that the university might have offered. So they chose to take the test, but they weren't required to take the test because they were going to be virtual.
Okay. Yeah, I'm gonna let's hear from Mr. Feinberg on rebuttal. We need you to unmute yourself, sir.
Sorry, is that better?
Yes.
What I started to say is that the notion that NYU didn't care what these students did and that testing was the only thing that they cared about before the term started, I think is not borne out by the admonitions that I read to you earlier, and really can't be the basis for a decision here. And the NYU has a compelling interest here in ensuring the safety of not just its students, but its faculty, many of which are older and more vulnerable to COVID. Council mentioned the August 5th policy. The August 5th policy that NYU adopted is limited to on-campus buildings. And so it didn't purport in any way to govern conduct outside of that limited context. And that's why, even though there was originally a charge against these students under that policy, it was dropped because it really doesn't apply here, and it really doesn't help petitioner's argument at all. The key communications, the key communications that NYU put out are the July 30th communication and the August 14th communication. And then as to what state and city guidelines were, counsel referred to two things that are in one of her complaints. And I believe that I'm not sure that the actual city and state guidelines are in the record. I think they may be referred to by internet links. But if I could have an opportunity to respond to that argument, because I do think that city and state guidelines, even at the time, made clear that you weren't supposed to be partying the way these students were, and that large gatherings in crowded circumstances. Look at those photos. These kids aren't.
I know what you're asking for, and the reason that I'm somewhat hesitant is you can't have more argument. It's one thing for you to give me the executive orders, and I'm happy to look at them. I actually think executive orders are things that I could take judicial notice of. We'd be able to look at them, but beyond the citation, I don't want no letters. I don't want any argument. Just want the citations And
Okay.
send the copy to Ms. Edler, and that would be fine.
I will do that, Your Honor. There's one other thing that I wanted to bring to your attention, and this is at page 566 of the record, because now talking about that August 14th video and the admonition against going to bars and going to parties that the August 14th video had, Ms. Edler, during the argument in front of Judge Edmeade, said the following. So that video recommended that students follow COVID protocols when they are off campus, and recommended that they avoid bars and parties, which frankly, those are the same recommendations being made by the state and city, because the COVID protocols were all put in place by New York State and New York City. And so that supports the argument I'm trying to make, that state and city guidelines, in fact, at that time, prohibited the sort of parties
that would be a different issue, quite frankly. I mean, that would be more like what Justice Scarpula was talking about, where, you know, students know they're not supposed to drink underage, and you don't have to say it in the policies of NYU if it comes under the broad panoply. It's illegal, you know?
What I'm trying to say, Your Honor, is that the August 14th video, which is, I think, as clear as day in terms of what guidance it was giving to NYU students, was reflecting what the status of things was at the time under state and city rules.
Okay. All right. All right. Thank you both. Fascinating case. And with that, we're going to close this session of the Appellate Division.
Thank you, Your Honor. It's been a long afternoon.
It has.